internally, externally, everywhere off. This just turns it off for YouTube and gives them an image. So for right now, while we're in this room, waiting for the judge to come in, we leave it sitting in an image. When the judge comes in and we're ready to start playing, see the play button, stream, image. Stream the video.
So, wait a minute, I'm sorry. When the judge comes in, they
You can hit stream.
Yeah, and then you're going to probably let it stream for a while because but like when he leaves, you want to switch to image.
So those are the only two I'm really going to have to worry about.
That's correct.
Right, only thing that's gonna change for you is say the judge says,
All right. Support a comment, please, from Lake County is now in session. The Honorable Eugene A. Lucci presiding.
May be seated. We're on the record. This is case number 22 CR 000345, State of Ohio versus Devonair McCullough. Mr. McCullough is in court represented by counsel. Assistant Public Defender Ashlyn Carroll, representing the State of Ohio, is Assistant Prosecuting Attorney Haley Gold. The defendant was here on June 7th of 2022. He waived indictment, pled guilty as charged. Count 1, possession of a fentanyl-related compound, felony 5, and a forfeiture specification. And count 2, having weapons while under disability, felony 3, and a forfeiture specification. I referred him for a pre-sentence investigation and report and set sentencing for today. I revoked his bond. I have received a pre-sentence report prepared by the Lake County Adult Probation Department dated June 22nd, 2022. I have read this document. I will make it part of the record. The PSR shows that the jail credit as of today is 120 days. Do you agree with that figure?
Yes, Your Honor.
Any reason, any other modifications?
No, Your Honor. No.
Any reason not to proceed?
No.
You may address the court first.
Thank you. Mr. McCullough did take responsibility for this situation. He did plead by way of information. He was very candid and open in the PSR about why he did have a firearm, why he did have those drugs.
Hold on one second.
Excuse me, Judge. The clock is now running.
Is it on now?
Yes.
All right. Let me back it up then, because that wasn't recording. And I have to wait for the hourglass to stop turning and turning. Because even though the clock's on, it's still not recording. love it when the electronics don't report to work on Monday morning. I'm going to close it out and try to reboot. It's still not recording. And now everything's gone gray. It's not even letting me close it out. Hold your thought, Miss Carroll.
Will do.
Dave, you want to call IT? She's probably going to say reboot the entire system. I apologize.
Thank you very much. She's on her way.
read this?
Go ahead. And I don't know if you have to reboot the entire
Take the whole thing.
system.
I'm gonna try just this first. Sorry.
Okay, this is case number 22CR000345, State of Ohio versus Devanir McCullough. Mr. McCullough is in court, represented by counsel. Assistant Public Defender Ashlyn Carroll, representing the State of Ohio, is Assistant Prosecuting Attorney Haley Gold. The defendant was here on June 7th, 2022. He waived indictment, pled guilty by way of prosecutor's information to count 1, possession of a fentanyl-related compound, felony 5, a Division B offense, and a forfeiture specification for contraband and instrumentalities. Count 2, having weapons while under disability, felony 3, and a forfeiture specification for the firearm, magazine, and ammunition. I referred him for a pre-sentence investigation and report, set sentencing for today, and revoked his bond. I've received a pre-sentence report prepared by the Lake County Adult Probation Department dated June 22nd, 2022. I've read this document. I will make it part of the record. The face sheet shows 120 days of credit as of today. Ms. Carroll, does the defense agree with that figure?
Yes, Your Honor.
Any modifications to the PSR?
No, Your Honor.
Any reason not to proceed?
No, Your Honor.
You may address the court first.
Thank you. Mr. McCullough did take responsibility for this case by pleading by way of information back on June 7th. He was very open and honest with the probation department as to the circumstances that led him to this situation. When he was 16, he was followed home and shot multiple times. He had multiple surgeries from a collapsed lung. It was a very traumatic experience for him. He did acknowledge in the pre-sentence report that he started hanging out with the wrong people when he was 17, and then when he was 18, he got a slew of felonies that led him to prison. The only cases he's had since he was 18 are a previous weapons case and this one. He did acknowledge that the reason that he was carrying a firearm was because of the previous situation that he had experienced, as well as the fact that 2 of his brothers he lost to gun violence. And so it was in a hoax to protect himself. He does realize that he is not allowed to own a firearm or possess a firearm, and that he was in the wrong in that situation. These traumatic experiences did lead him to using marijuana and pills, and that was the situation with the pills that were found, the fentanyl-related compound. And he does still have a holder in Cuyahoga County, a probation violation for that previous weapons under disability charge. He's expecting a prison sentence there, but doesn't know what's going to happen. So we are asking the court to impose a 9-month sentence. He does have 120 days of credit. Thank you.
Devanir McCullough, the law allows you to say whatever it is you want me to consider before I sentence you. What do you want me to know?
I want you to know I made a mistake and I made my bed and I lay in it I've been through a lot of my life, you feel me? And it's just, once you've been through so many traumatic situations, it's hard to kind of like, it's not hard, I can't say it's hard, but it's just like, I felt like a lot of times where I feel like if I could defend myself, then I would do that, even though I know it's not right, but I just made a mistake. That's it.
But you were on probation for making the same mistake. You still had another year, and
I was on probation because I was in a car, and it was a firearm under a seat which belonged to the person who was in the front seat, but being around a firearm, I guess they say, I had to cop out. So that was what that situation was. But
you were carrying this on your body when you ran from the police, correct?
Oh yeah, this time, yes, sir.
All right, let me hear from the state.
Thank you, Your Honor. The state is asking for 18 months prison.
I've considered the record, the oral statements made, the pre-sentence report, my conference in chambers with counsel and probation, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing pursuant to Revised Code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden on governmental resources. I've considered the joint recommendation of the parties for a prison sentence, but with different lengths of term. I've reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I have considered all relevant factors, including the seriousness and the recidivism factors set forth in Divisions B through E of Revised Code Section 2929.12. In that regard, there are factors that, or is a factor that makes the offense more serious. The fact that the defendant was armed when he ran from the police, in terms of making the offense or offenses less serious. The offender did not cause or expect to cause physical harm to person or property. That vehicle wasn't involved in a collision, correct? I mean, the original call was a vehicle with heavy damage to it. That was pre-existing?
That's correct.
Okay, so it wasn't related to this offense?
That's correct.
That was just the reason why the police were called?
Yes.
All right. In terms of recidivism, there are factors that make recidivism likely. The defendant was on probation out of the Cuyahoga County Court of Common Pleas. He was placed on 3 years of probation in September of 20, and this offense occurred March of 22, so he was about halfway through the period of probation. At the time he committed this crime, the offense out of Cuyahoga County on which he was on community control was the exact same having weapons while under disability, felony 3. The defendant was ordered to complete an inpatient drug treatment program on January 5th of 2021. The defendant has a previous criminal history and history of juvenile delinquency. In 2015, Cleveland PD arrested him for aggravated robbery F1 and theft M1, and the juvenile court transferred it to the general division of the Common Pleas Court. What happened with that case? I don't see a disposition on it. Kaylee, do you know what happened on that? Do you know?
I don't know, Your Honor.
All right. Mr. McCullough, what happened on that case? What was the disposition?
4 years.
4 years? Okay. So they gave you 4 years in prison? All right. And that was a later case, one committed 2 months later, kidnapping, F1, 3 counts, aggravated robbery, F1, felonious assault, F2, carrying concealed weapons, F4. That was all part of that 4 years?
Yes, sir.
Who was the judge in that case?
Marine Clancy.
And then an assault in the juvenile court with a finding of delinquency. Then as an adult, robbery F2. That was with Maureen Clancy, so that robbery was also combined with the 2 prior robberies and kidnappings, correct? Wasn't that was all?
Only 2.
Only 2 cases?
One that I believe did start in the juvenile court, and then one from the...
I've got 2 starting in juvenile court.
And they both got bonded over.
They both got bound over, and then as an adult, I've got a robbery F2 where you got the 4 years with the other case.
Your Honor, the way that I typed it out is the juvenile, he was arrested for those cases as a juvenile, and when they were bound over to the common pleas as an adult, those are the same charges as the juvenile. I tried to write it out the best I could in the juvenile section.
Okay.
So it's the same.
All right.
charges.
So the defendant was admitted to prison October 4th of 2016, released July 30th of 2019. You are on post-release control. but the post-release control was terminated by the court with the commission of another 2 counts of aggravated robbery, kidnapping, weapons under disability, carrying concealed weapon. Or did Judge, this is confusing, did Judge Gall terminate the post-release control, or did Maureen Clancy terminate the post-release control?
Daniel Gallman terminated.
Okay. And that was with the weapons under disability. And did you complete that inpatient drug treatment program that he ordered?
I never started.
All right, well, that was ordered January 5th of 2021. So, in addition to previous criminal history, which shows significant crimes of violence, there's been a rehabilitation failure, a failure to respond to community control. There's a pattern of substance abuse, and the offender refuses to acknowledge a problem or accept treatment or to complete treatment ordered of him. The court finds no factors indicating recidivism is unlikely other than he pled by way of a prosecutor's information rather than a grand jury indictment. On the F5 under 2929.13b1, there is no presumption in favor of community control because of the prior prison, because of the presence of the firearm. Court determines that the defendant is not amenable to an available community control sanction, that prison is needed to protect the public from future crime, that a minimum sentence would demean the seriousness of this offender's conduct. Accordingly, it's the sentence of this court that you serve a period of incarceration in state prison on count 1 for 9 months and on count 2 for 18 months concurrent for a stated term of 18 months with credit for 120 days on each count. You're to forfeit all contraband instrumentalities, including the firearm, magazine, ammunition. You're to pay the costs of confinement, prosecution, supervision, treatment, and court costs. Upon your release from prison, you could be on post-release control in the discretion of the Ohio Adult Parole Authority for a period of up to 2 years. They can return you to prison for up to 9 months for any one violation. All of that time is part of the sentence. Should the violation be a new felony, the judge in a new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for the greater of 1 year or whatever length of time remains unexpired on that potential 2 years of PRC. All of that time is already part of the sentence. As I explained to you when I took your plea, you may be eligible for it, be offered, and be able to earn some credit by engaging in educational, vocational, or rehabilitational programming offered to you for that purpose. Prison credit is normally capped at 8%. However, since you do not have a high school diploma or GED, you may be able to stretch that to 10% while in prison, obtaining your GED. So long as you owe any court costs, the state can block your motor vehicle license plates until they are paid in full. And let me explain again, you are under a firearms disability. You cannot purchase, own, possess, or use firearms or ammunition for firearms. That's both state and federal. Bond, if any, is released. Is there anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
No, Your Honor.
All right, good luck. We're adjourned.
next two are out, so
I'm sorry?
the next two are out, so we'll be up when it starts.
Okay, thanks.
We're on the record. This is case number 22 CR 000383, State of Ohio versus Ari M. Winbrand. Is that how you pronounce it?
Perfect.
Mr. Winbrand is in court, represented by counsel, Attorney Eric Norton, representing the State of Ohio as Assistant Prosecuting Attorney Michael Fife. Mr. Winbrand, you are charged in a one-count amended information filed by the Lake County Prosecuting Attorney on June 28th, 2022. The original was filed June 17th of 2022. The charge is aggravated possession of drugs, felony 5, a Division B offense. This carries a maximum penalty of 12 months in prison and a maximum fine of $2,500 and a maximum driver's license suspension of 5 years. It's my understanding you wish to give up your right of indictment and plead guilty as charged. Is that your understanding as to what you want to do here today?
Yes, sir. Your Honor.
You understand you have the right to have the Lake County Grand Jury consider the evidence as presented by the prosecuting attorney and for the grand jury to determine the charge or charges. In doing so, they could land on the same charge we have here. They could charge you with something more, something less, or nothing at all. The point is, it's totally up to the grand jury. Do you understand that?
Yes, Your Honor.
Have you discussed this decision about waiving indictment and pleading guilty by way of prosecutor's information?
Yes, Your Honor.
And has your attorney answered all of your questions to your satisfaction about that topic?
Yes.
Do you give up the right of indictment?
Yes, I do.
I'm going to hand you a document called Waiver of Indictment. Make sure you've read it. Make sure you understand what it says. Make sure you agree with what it says. And if you sign it only because that's what you want to do.
Judge, both the defendant and defense counsel have signed the waiver of indictment. As of may I approach?
Yes. I'll make the waiver of indictment part of the record in the case. And it's not immediately apparent to me what's the difference between the information and the amended. What was the amendment?
Judge, I believe the information that was filed was just an unsigned Mr. Colson hadn't signed.
Oh,
And it just,
okay.
I checked today because I was wondering the same thing, and the recent one was just actually signed. by
Okay,
Mr.
so the clerk filed it without Mr. Colson's signature
I
on it?
believe that's
Okay. So before I can accept your plea of guilty, I have to determine if you know and understand the rights you are giving up, the consequences of a guilty plea, and that you are entering this plea of guilty of your own free will. How old are you?
36, sir.
And how far did you go in school?
I graduated Beechwood High School, and I did some college in Vegas and some college with the Carpenter's Apprentice School.
All right. And do you have the ability to read, write, and understand the English language?
Yes, Your Honor.
Do you hold any kind of state-issued occupational license or certification?
No.
Are you a U.S. citizen?
Yes.
Are you currently under the influence of any drugs, alcohol, or medication of any kind?
No, Your Honor, just insulin.
And have you taken any drugs, alcohol, or medication of any kind within the last 48 hours?
No, sir.
Other than insulin, did you have
Yeah.
insulin within the
Insulin,
last...
Just diabetes.
Okay. And so, when did you last administer the insulin to yourself?
2 hours ago?
All right. And it's for diabetes.
Yeah.
And does the insulin interfere with your ability to think clearly?
No, not at all.
If you didn't have it, would that interfere with your
Definitely.
ability to think clearly?
Yeah.
All right. So you are thinking clearly now?
Yes.
All right. No trouble understanding me?
No.
And no trouble understanding what you and your attorney talked about before we started the hearing, correct?
Correct.
Have you ever been medicated, hospitalized, or treated for any mental illness in your life?
I did an IOP for drug addiction and mental health before. I recently went to what do they call it, a drug and alcohol assessment to see if I needed to go more, and they told me just to seek out some private therapy. And
Where did you have the drug and alcohol assessment?
At Highland Springs.
And when did you have that?
2-3 weeks ago.
All right. And did you have that because of the charges here?
That and also just stressors in my life.
All right. You're not on any mental health medication?
No, Your Honor.
Have you received a copy of the information and read the charge?
Yes.
Do you understand the charge?
Yes.
Did you discuss that charge with your attorney?
Yes.
Did he answer all of your questions to your satisfaction about the charge?
Yes, sir.
Do you agree with what the charge says?
Yeah.
And do you wish to sign it? Or do you wish to plead guilty to it?
Yes, I do.
I've been handed a 4-page document called Written Plea of Guilty. You probably went over this document with your attorney before we started the hearing. Is that correct?
Yeah.
And did you read this document?
This one right here?
The 4-page document?
Oh, yeah.
Do you understand it?
Yes, sir.
Did you discuss that document with your attorney?
Yes, sir.
Did he answer all of your questions to your satisfaction about the document?
Yes, sir.
Do you agree with what it says?
Yes.
And do you wish to sign it?
Yes, sir.
I'm going to go over the charge you are proposing to plead guilty to so that we are all on the same page. The charge says that on February 15th of 2022 in the city of Mentor, Lake County, Ohio, you knowingly obtained, possessed, or used methamphetamine, a Schedule II controlled substance. That's called aggravated possession of drugs. It's a felony of the 5th degree. It's in violation of Revised Code Section 2925.11, and when it comes to determining whether I should send you to prison, Division B controls. Do you understand that charge?
Yes, sir.
And is that the charge you wish to plead guilty to in this case?
Yes, sir.
You understand if you plead guilty to the charge, you are admitting you committed the crime.
Yes, sir.
Do you understand by pleading guilty you give up any defenses you may have?
Yes, sir.
You understand by pleading guilty you are giving the court the power to sentence you immediately.
Yes, sir.
You understand that any rulings previously made by this or any other court on this case prior to this moment could not be appealed because you're pleading guilty now.
Yes, sir.
You have certain trial rights. You're giving them all up by pleading guilty. I am going to explain them to you one at a time. I need to make sure that you know and understand you have these rights and that you're voluntarily giving up these rights.
Okay.
As I explain your rights to you, if you have any question about what I'm saying or if you need a better explanation, you need to speak up and let me know. Otherwise, I will assume you understood and answered the question that I asked you. Fair enough?
Yes, sir. Your Honor.
You do not have to plead guilty. You have a right to have a trial to determine whether you're guilty of any crime. That trial would automatically be by a jury in this court unless you decided you wanted a non-jury trial. A non-jury trial is a trial where you want the judge not only to make all of the decisions throughout the case, but you want the judge to make the ultimate factual determination in the case whether the state can prove your guilt beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
Do you understand that a trial gives you the ability to test every aspect of the state's case, both factual and legal?
Yes, Your Honor.
You understand with a jury trial, the jury makes the decision. I don't, whether the state has proved its case against you. Furthermore, it takes all 12 jurors to agree that you're guilty before it's even possible for you to be convicted. Do you understand all of that?
Yes, Your Honor.
The state of Ohio is required to prove your guilt beyond a reasonable doubt. If the state failed to prove even one essential element of the particular charge beyond a reasonable doubt, you could not be convicted of that particular crime. Your plea of guilty provides the court the entire factual and legal basis upon which to convict you and sentence you, and by your plea, you are relieving the state of any obligation to prove anything, let alone prove it beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
You have the right to confront your accusers, meaning to have your attorney question all of the state's witnesses under oath in front of the judge and jury. Do you understand that?
Yes, I do.
You have the right to use the subpoena power of the court to compel witnesses you need to come here to testify for you, especially witnesses who are reluctant to come to court out of state or incarcerated someplace. I can get them here for you. Do you understand that?
Yes, I do.
You understand you have the right to tell your side of what occurred here and testify in your own defense. Or you could refuse to testify. It's one way or the other, but it is your choice. No one can compel you to testify if you didn't want to, and if you chose not to testify, that could not be used against you to prove that you were guilty. In fact, the prosecutor could not even comment on your silence to infer you might be guilty, have something to hide, maybe have a prior conviction. The jurors would be told you have that constitutional right not to take the stand and testify. We would select only individuals to serve as jurors in your case who answer under oath during jury selection that they will uphold that right. Do you understand all of that?
Yes, Your Honor.
Do you understand that if you were not pleading guilty today, you would always be represented by an attorney at law throughout this case? Even if you could no longer afford counsel, counsel would be appointed by the court, paid for by the taxpayers, free to you.
Yes, Your Honor.
Do you understand that if you were not pleading guilty today, you could appeal any of the decisions I would make throughout the case? You could appeal the jury's verdict. You would have a transcript typed up of everything that was said or done in this court, so you can demonstrate to a higher court any mistakes made here to get those mistakes corrected, and an attorney to handle that appeal for you. And if you could no longer afford that, all of that would be provided to you free of charge, paid for by the taxpayers. Do you understand all of that?
Yes, Your Honor.
Do you understand a plea of guilty is a complete admission of guilt?
Yes.
Do you voluntarily give up all the rights that I just explained to you and wish to have this court accept your plea of guilty to one count of aggravated possession of drugs, felony 5?
Yes, Your Honor. I do.
Are you now, or were you at the time of this offense in February of this year, on parole, post-release control, community control sanctions, or probation to any court anywhere?
Yes.
Tell me about that.
I had literally 5 years to the day that I got arrested. I was arrested in Michigan for driving under suspension, and I was
So you were convicted of? You were convicted of what?
I was convicted of maintaining a drug house, it was called.
Maintaining a drug house
Yes,
in Michigan.
yes.
And were you still on probation or community control or parole, post-release control, on February 15th of 2022?
Yes, Your Honor.
And how long a period of, and were you sent to prison?
No, Your Honor.
You were put on probation,
For 5 years, yes.
community control for 5 years. And when were you placed on probation or community control?
August 18th,
Of what year?
17, 5 years ago? Yeah,
All right. So you still had roughly
6
6 months more of probation to complete. So has the Michigan court been informed of this arrest?
yeah, they put me in county for a week in Cleveland, in Cuyahoga County, and then they extradited me to Michigan to get my arraignment.
All right. Did they extradite you to Michigan?
Yeah.
And when did you go back to Michigan?
For the day, really. They just kept me overnight.
But you went back right away?
Yeah.
Okay.
I was in Cuyahoga County for a week first.
All right.
Wait.
And so what sanction did the Michigan court give you?
An ankle bracelet, and I have the final court on August 11th.
All right. So you're still wearing the GPS device on your
And also
ankle?
I've been told to do 3 drug tests a week, and then they knocked it down to 2. And I passed every one of them.
Okay. So they did take some action as a result of the violation here?
Yes. Very expensive, actually.
Have you ever been to prison in your life?
Jail, yes.
Prison.
no.
Okay. So you understand, by pleading guilty, you are voluntarily giving up your liberty for whatever length of time I sentence you to jail, prison, or community control.
Yes, sir, I do.
And you understand on this case, I can send you to prison for 12 months. If I did send you to prison, 6 months would be the minimum, and it would be a whole number of months between 6 and 12, and I can fine you up to $2,500.
Yes, sir, I understand.
You understand that I can suspend your driver's license for a period of up to 5 years.
Yes, I do.
You understand you would forfeit any contraband or instrumentalities involved in the offense. You have
Yes,
to
sir, I
verbalize.
understand. Yeah.
You understand that while in prison, you may be eligible for, be offered, and be able to earn some credit against prison time to be served by engaging in educational, vocational, or rehabilitational programming offered to you for that purpose. The prison credit is normally capped at 8% of time to be served or a certain number of days. Do you understand that?
I understand, sir.
Upon your release from prison, you could be on post-release control, PRC, in the discretion of the Ohio Adult Parole Authority for a period of up to 2 years. They'll give you rules. You violate their rules, they can return you to prison for up to 1/2 the original prison term I give you for all violations in the aggregate. All of that time is already part of the sentence. Do you understand that?
Yes, sir.
Further, if your violation of PRC is a new felony, the judge in the new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for another year. All of that time is already part of the sentence. Do you understand that?
Yes, Your Honor.
You understand that if I chose not to send you to prison, I would place you on community control sanctions for a period of up to 5 years.
Yes, Your Honor.
As part of the community control sentence, there'd be various probationary conditions that I would establish for you in the case, and you would have to abide by those probationary conditions, which could include time in a local jail, fine of up to $2,500 I mentioned, abstinence from alcohol and drugs of abuse, periodic screens to monitor your compliance, any treatment I determine you need, substance abuse or mental health, community service, the license suspension up to 5 years that I mentioned earlier, the forfeiture that I mentioned, a no contact order, anything I determine you need to do. Do you understand you would be required to perform exactly what I tell you to do, exactly how I tell you to do it?
Absolutely, Your Honor.
If you fail to do so, you'll be brought back before me on a probation violation. I will conduct a hearing. If I determine that you did violate your community control sanction, I can extend the period of time that you're on community control for up to that 5-year maximum. I can increase the nature and severity of the other conditions under the community control, meaning more time in jail, more treatment, more things to do. Or I can terminate community control altogether and just send you to prison for 12 months. Do you understand that?
Yes, Your Honor.
You understand that by virtue of a felony drug offense, you are disqualified under both state and federal law from purchasing, owning, possessing, or using firearms or ammunition for firearms.
Yes, Your Honor.
You understand that there are other disqualifications that accompany a felony conviction. If I did send you to prison, you cannot vote from prison. You'd have to re-register to vote upon your release from prison in order to regain your ability to vote. You cannot serve as a juror on a criminal case while on community control sanctions, while in prison, or on post-release control, and you cannot hold any position of public honor or trust. Do you understand that?
Yes, I do, Your Honor.
In addition to the fine that I mentioned, do you understand that I will order you to reimburse the government the cost of confinement, community supervision, any treatment, and court costs?
Yes, Your Honor.
And you understand the cost of confinement also includes transportation costs between the court, the jail, and the prison institution.
Yes, Your Honor.
You understand I will enter a judgment against you for the costs of prosecution.
Yes.
If you fail to pay that judgment or timely make payments on a payment plan approved by the court, and you are serving a community control sentence rather than a prison term, you may be able to substitute community service to work it off. By local rule, you'd work it off at the rate of $10 per hour. Each hour of work performed reduces the judgment by that amount. Do you understand that?
Yes.
You understand a failure to pay all fines and costs in full can result in the state blocking your motor vehicle license plates until they are paid in full.
Yes, Your Honor.
Do you understand all of the potential penalties?
Yes.
Do you have any question at all as to what can happen to you as a result of your plea of guilty today?
No, Your Honor.
Do you understand no promises have been made by the court, the prosecutor, your attorney, or anyone as to what I will do when it comes time for sentencing?
I understand that.
And you understand no one can promise you what I'll do because as I sit here, I don't even know what I'll do. You understand that?
Yeah, sure.
And Mr. Fife, has the state of Ohio promised Mr. Winbrandt anything in this case, and in particular with regard to a sentencing recommendation?
Yes, Judge, the state has agreed to recommend community control sanctions.
All right, Mr. Winbrandt, did you hear and understand what the prosecutor just said?
Yes, I did.
So let me restate that. When we reconvene for sentencing in about a month or 5 weeks or so, the state is prepared to recommend community control rather than a prison term. Of course, there are some preconditions to that. Number one, your record has to be what the state expects the record to be. They've done a check, and if something comes up with the probation department that the state wasn't prepared for, then that might alter the way the state thinks of this. You have to show up for the hearing. If you don't show up for the hearing, the state's not going to recommend, and I'm not going to hold the state to its recommendation of community control.
I understand.
You can't commit a crime between now and the time of sentencing. You have to obey your bond conditions between now and sentencing. So you understand all of those are prerequisites for me to order the state to stand by its promise to you to make that recommendation of community control.
Yes, Your Honor.
Now, you understand that even if the state does recommend community control, I'm not bound by it.
Yes, I do.
I can still give you a prison sentence.
I understand that.
And do you still wish to plead guilty understanding that?
Yes, Your Honor.
Has anyone else made any kind of promises or threats to you in order to get you to plead guilty?
No, Your Honor.
Are you entering this plea freely and voluntarily?
Yes, Your Honor.
Have you told your attorney everything you considered important in this case?
Yes, Your Honor.
You didn't hold back anything from him?
No.
Have you had enough time to discuss what you're doing in this case with your attorney?
Yes, Your Honor.
Although this may be your attorney's recommendation for you to plead guilty to this charge as charged, is this your own decision and voluntary act to do so?
Yes, it is.
Has your attorney done everything you've asked him to do for you in this case?
Absolutely.
And are you completely satisfied with the legal representation provided by Eric Norton, your attorney?
Very much so.
Mr. Fife, what would the facts show if the case went to trial?
Thank you, Judge. Had this case proceeded to trial, the facts would show that on February 15th of this year in Mentor Lake County, Ohio, the Mentor Police conducted a traffic stop upon the defendant's vehicle. After a search of the defendant's person, police located a vial of white powder found in the defendant's pocket. That vial was sent to the Lake County Crime Lab, where it was confirmed to be 1.06 grams of methamphetamine, a Schedule II substance. Thank you.
And Mr. Winbrandt, did you hear and understand everything the prosecutor just said?
Yes, I did.
And is everything he said true?
Yes.
What is your plea to count 1, aggravated possession of drugs, felony 5?
Guilty.
I'm going to hand you that written plea of guilty document we talked about earlier. Make sure you've read it. Make sure you understand what it says. Make sure you agree with what it says. And if you sign it only because that's what you want to do. I've made my markings on this document in red so you can easily tell what I've done to it since you last saw it.
Thank you.
Judge, I've witnessed both the defendant and defense counsel sign the written plea of guilty. I have done that as well. May I approach?
Yes. I will sign the judgment entry at the end of the written plea of guilty, which has been signed by the defendant in open court, witnessed by both attorneys. I'll make this document part of the record. The record should reflect that defendant Ari M. Winbrandt was here with attorney Norton in open court. I informed Mr. Winbrandt of all of his constitutional rights. He's made a knowing, intelligent, and voluntary waiver of those rights. I also find he understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be knowing, intelligent, and voluntary, I accept his plea and find him guilty as charged. 1 count of aggravated possession of drugs, methamphetamine, a felony of the 5th degree, in violation of Revised Code Section 2925.11, a Division B offense. I'm going to refer you to the Lake County Adult Probation Department for a pre-sentence investigation and report and a drug and alcohol evaluation with a brief mental assessment by the court's forensic psychologist. Sentencing will be held in this court on Monday, August 22nd, 2022 at 1:45 p.m. Mr. Norton, I don't know if you had a preview of that date.
I think that date will be perfectly fine, Judge.
Okay, August 22nd, 1:45.
I'll double check it right now.
Mr. Winbrand, do you still live at 1262 Eastwood Avenue in Mayfield Heights?
Yes, Your Honor.
And do you have a land phone line at the residence? Your cell phone?
Yes, just a cell phone.
What's that number?
440-799-3104.
And any reason not to continue bond?
No, Judge.
What's bond set at?
It was 15,000, 10% surety. It's posted on February 20th.
In Your Honor, August 22nd is perfectly fine. I did check, but thank you.
Okay. Bond is continued. I'm going to print out the referral for the pre-sentence investigation. You're to take your copy of this and go directly from the court to the 3rd floor of the sheriff's office. That's the building to the north of here. That's the location of the court's adult probation department. They'll do an intake interview. They'll take a urine sample for analysis. If you test positive for alcohol or any substance of abuse, or if you fail to go over there, as I just ordered, I'll revoke your bond and you'll stay in jail until sentencing. Understood?
Understood, sir.
Is there anything further from the state?
No, Your Honor, thank you.
Defense?
No, Your Honor, thank you.
All right. I'll see you on August 22nd.
Thank you, Your Honor.
We're adjourned.
I'll walk over with
All rise.
Yes.
I know you do this.
Oh, then maybe.
and I'm just going to do some more.
I have it all.
Go down to the library.
Okay.
Thank you, everybody. See you next month.
Okay.
We're supposed to stay up here for the next week. She's gonna see.
Yeah.
She's up there. Okay.
Riveting.
upgrade system.
That's all I did when I was a kid.
Yeah. Didn't have all these fancy sport rooms. Well, we did have a gator gun. Yeah,
Shit,
shit,
we used to-
like 5
I
seconds.
used to drink salt head, but playing football, they give you
Yeah.
salt head, so when you have me down here, it's like, oh.
Freaking dog got me up 3 times last.
Yeah, my daughter moved to Chardon about a year and a half ago and took our child lab with her. She trained as fast as we can because, but it still comes over on the weekends every now and then. But we haven't gotten a dog yet. So I don't know if we can go with that. Only bad about dogs, you can't like pick up and go. Like, you know, like we have no kid, our kids are all older now, so it's like we can just go somewhere. You don't have to worry about animals. Our cat died about 6 months ago. We had no animals, so it's like you can just go. You don't have to worry about getting the sitters and kennels.
So we're going to stick us use a chocolate lake.
This is case number 22CR000426, State of Ohio versus Rochelle R. Basham. Ms. Basham is in court, represented by counsel, Assistant Public Defender Mary Springer. Representing the State of Ohio is Assistant Prosecuting Attorney Haley Gold. The defendant was last here on June 28th, 2022. She waived indictment, pled guilty as charged by way of prosecutor's information to count 1, possession of heroin, felony 5, and a forfeiture specification for contraband. I referred her for a pre-sentence investigation and report and set sentencing for today. I reset her bond at own recognizance with conditions that she enter a residential treatment facility immediately upon release from the Lake County Jail, and that she have no involvement with drugs or alcohol. I have received a pre-sentence report prepared by the Lake County Adult Probation Department dated July 15th, 2022, a drug and alcohol evaluation with a brief mental assessment prepared by the court's forensic psychologist. I have read these documents. I will make them part of the record. The face sheet shows credit of 7 days. Defense agree with the credit and any modifications needed.
No, Your Honor.
And you note,
I'm sorry, we do agree with the jail time credit and we
but no
don't need any
modifications.
modifications.
Right. Any reason not to proceed?
No.
Go ahead.
Thank you, Your Honor. Ms. Basham would ask the court at this time to sentence her to a term of community control sanctions. She's 27 years old. She's a high school graduate. This is her first felony conviction, and it is a low-level drug-related offense. Unfortunately, Ms. Basham has been struggling with substance use for many number of years, and the first way that she got introduced to drugs was with her boyfriend, who she was with for 7 years. He passed away last year on her birthday, unfortunately. But Ms. Basham has been struggling with first pills, and then it evolved to heroin and really anything that she could get her hands on. She had a couple of cases at the Willoughby Municipal Court, misdemeanor offenses, and she was sentenced to JTP. But I think most recently, the most recent offense, this offense is really what has scared her. When she went to the jail, she was really struggling with relapsing. She was throwing up blood. She was really, really ill. And she realized at that time that this behavior has to change. And so Ms. Basham served her Willoughby sentence, had a cooling off period in our jail, And then when she was ready, got a hold of TJ Weinman from my office and asked for him to help coordinate some inpatient treatment for her. So Ms. Basham has been at New Beginnings in Ashtabula since the 19th of this month. It is expected to be a 90-day program. She's very eager to complete that. She's been enjoying it so far, and she feels like it's very beneficial to her. After she completes that program, her plan is to go back and live with her parents who reside in Geauga County in Chesterland. She has a really good family. Her parents have been married for 27 years, and they're supportive of her when she's on the right path, and that's what she hopes to do in the future. She would like to attend aftercare with Lake Geauga because that is a lot closer for her than Ashtabula, but she's really grateful that Ashtabula had a bed for her to go to. So she would ask the court to sentence her to community control. She will finish the program at New Beginnings and would like, as I indicated, to complete aftercare with Lake Geauga. Thank you, Your Honor.
Rochelle Basham, the law allows you to say whatever it is you want me to consider before I sentence you. What do you want me to know?
Your Honor, I would like to complete New Beginnings and to go back to my parents with aftercare treatment. And I think it's time.
Where do your parents live?
Geauga in Chesterland.
And how was the withdrawal?
It was bad at first, but now I'm feeling much better and almost at 100%.
It was pretty violent.
Yeah, I went to the hospital and was there for a week.
So you were vomiting blood?
Yeah, and having seizures.
Never want to go through that again?
No, never in my
Then
life.
don't take drugs, and then you won't have to go through it again. So you've been at New Beginnings for a couple weeks now?
I was there last Tuesday. So
Last
tomorrow
Tuesday.
will be a week.
Are you employed?
No.
Let me hear from the state.
Thank you, Your Honor. The state asks that you adopt the state and defense's joint recommendation for community control.
Considered the record, the oral statements made, the pre-sentence report, drug and alcohol and psychological evaluations, my conference in chambers with counsel and probation, and statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution along with the public burden. I've considered the joint recommendation of the parties for a community control sanction. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders, in using my discretion to determine the most effective way to comply with the purposes and principles of sentencing. I have considered all relevant factors, including the seriousness and the recidivism factors set forth in the statute. In that regard, there are no factors that make the offense more or less serious. In terms of recidivism, there are factors that make recidivism more likely. The defendant does have a criminal history, however, it's misdemeanors and it is very shallow. In terms of making recidivism unlikely, the offender is genuinely remorseful and has already started a treatment program under 29.13b1. There is a presumption for community control. The court finds that the offender is amenable to an available community control sanction. That community control is appropriate, and the court will adopt the joint recommendation. I'm imposing a period of community control for 2 years, subject to the general supervision and control of the Lake County, Ohio Adult Probation Department under such terms and conditions that it finds appropriate. Among these, you shall not leave the state of Ohio without the permission of the court, and you shall abide by all laws, including but not limited to the laws related to firearms, deadly weapons, and dangerous ordnance. The court further imposes the following specific sanctions and conditions: a period of incarceration in a Lake County jail for 7 days with credit for 7 days already served. You are to complete the New Beginnings treatment program and stay at that facility for at least 90 days, following all recommendations, including aftercare recommendations, which can be done at the Lake Geauga Recovery Centers. Complete abstinence from alcohol and drugs of abuse, periodic screens to monitor your compliance, a minimum of 5 12-step program meetings per week, have a sponsor, and be involved in a home group. Have you been doing a 12-step program?
Yes, NANA.
And no problem with that?
No.
And you have do you have a sponsor in a home group?
Not yet. I have to be there
All right.
for 10 days.
All right, so I'm ordering that you do have a sponsor and a home group. And have you been attending in person?
Yes.
Okay. Some people do this by Zoom, and I don't think that fills the purpose of having the moral collegial support. You should have a mental health assessment and follow recommendations, have full employment or school or combination of employment and school, but outside of any establishments that sell or purvey alcohol or drugs as the primary source of revenue. You'd have one doctor, one dentist, one pharmacy at any one time prescribing or filling prescriptions for you. You're to inform the Adult Probation Department of any change of provider, sign medical releases so that they can monitor any drug-seeking activity on your part, and you're to inform your providers of your addiction. You're to take all medicines as prescribed and perform 100 hours of community service. You're to forfeit all contraband and instrumentalities, pay the costs of prosecution, confinement, community supervision, treatment, and court costs. A violation of this order will result in a prison term of 6 to 12 months. If you do end up in prison, post-release control is optional for up to 2 years. They'll give you rules. You violate their rules, they can return you to prison for up to 6 months in this case, even for one violation. Should the violation of PRC be a new felony, the judge in the new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for another year. All of that time, whether administratively or judicially imposed is already part of the sentence. If you do end up in prison, you may be able to engage in programming offered to you for that purpose, whereby you can earn credit capped at 8% or a certain number of days by completing the programming. So long as you are not in prison, you may be able to substitute community service to pay off the costs of prosecution, working it off at the rate of $10 per hour. Each hour of work performed reduces the judgment by that amount. That's in addition to the 100 hours of community service that I ordered as part of the sentence. So long as you owe any court costs, the state can block your motor vehicle registration, your license plates, until the court costs are paid. Bond is released. Is there anything further from the state?
Nothing further, Your Honor.
Defense?
Nothing further, thank you.
Probation? All right, good luck.
Thank you.
We're adjourned.
All rise.
Just call for the next day. The next one's in, so just call when you're ready. Just call. I said, the next one's in, so just call when you're ready.
Oh,
Yeah, for Gibson.
thank you.
All right.
Thank you.
Today, coming back later.
I was on today.
Very good.
Thank you. Have a good day.
See you later. Have you had a chance to go over the paperwork?
Well, he's just sentencing at this point. Yeah. So,
I'm just filling in.
but I did talk to him downstairs, so
Okay.
I'm ready whenever.
Okay, cool. I'll have him brought right up.
Looks good.
Yeah, that was. Yeah.
We were on vacation with the legs in June. Every morning I kept hearing them stud. Oh, it was a cardinal. It kept running until I had one time and then someone else was stoned.
I had my parents had a robin that lived outside their house, and I think it saw like other birds as like a rival, so it would see the mirror and just like or the windows and attack the window thinking it was a bird. Yeah.
You're OCO and ER?
OR.
OR, yeah.
Yeah.
Someone spelled it wrong.
It happens.
Thanks, guys.
Yeah.
anything.
Right.
I think I would have.
That's right, and that's, I wouldn't know the difference, so. Frustrating.
Damien's been logging out a lot. Where I would log back in, and I would turn my computer off, turn it back on, log back in.
Stephanie even said, "Are you all right now?" I'm like, "Yeah, why?" She goes, "You're pounding things around." I didn't realize that's all. I had a bunch of degrees, and I had to think straight about it because I was kind of a ton of cases. I think everybody's going to get two at least. There's 3 co-defendants on one case, and there's like 15 victims. And then we would be a notch above all the other.
Plus you got hair. Plus you got hair, so you have 2 notches.
Good point.
rise. This Court of Common Pleas for Lake County is now in session. The Honorable Eugene presiding.
May be seated. This is case number 22CR000468, State of Ohio versus Kenyon R. Gibson. Mr. Gibson is in court, represented by counsel. Assistant Public Defender Daniel Rush O'Connor. Representing the State of Ohio is Assistant Prosecuting Attorney Alexandra Cutts. The defendant was here on June 7th, 2022. He waived indictment, pled guilty as charged. Count 1, assault on a corrections officer, a felony of the 5th degree. I referred him for a pre-sentence investigation and report and set sentencing for today. I revoked his bond. I have received a pre-sentence investigation report dated June 29th, 2022. I've received a comprehensive psychological evaluation prepared by the court's forensic psychologist dated July 18th, 2022. I have read these documents. I will make them part of the record. Any inaccuracies, any modifications needed to the PSR documents?
Your Honor, I've reviewed all the documents.
And any reason not to proceed?
Your Honor, we're prepared to proceed today.
And do you agree the jail time credit is 67 days?
We do, Your Honor.
All right, you may address the court first.
Thank you, Your Honor. Your Honor, Kenyon is a very thoughtful young man. I've gotten to know him quite well over these past few months. During this time, I think he has benefited being on medication. He recognizes and expressed in the pre-sentence report that he messed up and that he showed remorse to the probation department as well as Dr. Rinsberg. We believe that community control would be appropriate in this circumstance due to the fact that Kenyon recognizes, one, that he acted wrong, but two, recognizes what he could have done differently. He recognizes that he's got to address some underlying anger issues, and he's prepared to do that. I believe that he has a lot of potential, and so because of that, we would be asking for him to have the opportunity to be on community control to address any mental health issues, any drug issues he's willing to address. Kenyon, I do believe, has a few words he'll want to say as well, but we do believe that because of the remorse he's shown, that he's recognized how he could have acted differently in those circumstances, that he's appropriate candidate for community control.
Kenyon Gibson, the law allows you to say whatever it is you want me to consider before I sentence you. What do you want me to know?
I'd like to start off by saying I never intended for anyone to get hurt. I learned from this incident that thinking before reacting can eliminate impulsive decisions. I intend on using this as a learning experience to better myself for the future. I'd like to sincerely apologize to Ms. Ritz for the harm I've caused her and her family, although there is no excuse for the harm I've caused. During those 10 days incarcerated at the Lake County Detention Center, I wasn't routinely receiving my medications before I suffered from mental illness. Therefore, I believe my actions were extremely out of character and has been weighing heavy on my mind and heart. I hope Ms. Ritz is okay and has a full recovery. Thank you, Your Honor.
All right, let me hear from the State of Ohio.
Thank you, Your Honor. Your Honor, this is an incident where defendant was on probation through the juvenile courts. He had been, basically he had left where he was supposed to be staying. There was a warrant out for him after he turned 18 or right around then. He turned himself in. So he was in the juvenile detention facility after he had turned 18, but he was still serving a juvenile probation violation. While he was there were various concerns with him being argumentative, not doing what the corrections officers had indicated on this specific incident. They were trying to take him to another location out of the cell that he was in, and he did not wish to go and would not cooperate. Multiple corrections officers, including Ms. Riss, had been involved in that, and during that time frame she was injured. She actually had 2 ribs that were dislocated, came out of place. She had indicated that it was very painful at the time, and that it took her about 45 minutes to get her breathing under control because it was so painful and so alarming to her. This injury was exacerbated by her physical condition. She had previously had a surgery in that basic area, and she was very concerned if there had been damage to the prior surgical aspect. She also, so we have the serious physical harm, the psychological harm, the concerns, and then the economic harm. Not all the treatment she received was covered. Thankfully, some of it was, but there were 2 bills that had not been covered for a total of $227.74. She actually had multiple medical appointments that she had to go to. They couldn't get both ribs in on the same occasion due to swelling and other issues, so they were first able to get one rib back into place and then another rib back into place. It's the state's understanding that visually she can see a slight difference in her body, not necessarily something that an average person would notice, but she is able to see that. Obviously the relationship with the victim facilitated this event. She was the corrections officer. He was in the juvenile detention facility. Since he turned 18 while in the juvenile facility, he does not have any other prior adult convictions, but he is 18 and he now has this assault on a corrections officer, felony of the 5th degree. He does have a juvenile history more than what he was in detention facility for. In 2017, he had disorderly conduct. That's when he began probation with Lake County. It was still in Lake County at that time. In 2018, he had another disorderly conduct and 2 probation violations. He also had a vehicular vandalism, as well as a case that included assault and disorderly conduct. He had a probation violation in that case. In 2019, he had adjudications for assault and disorderly conduct with a probation violation, a criminal damaging with 3 probation violations, and in 2020, a criminal mischief, with 2 probation violations. And he also had an obstructing official behavior. In 2021, he had an aggravated disorderly conduct, as well as a theft. That was the first offense that would have been a felony theft, and then an aggravated disorderly conduct. So he has 1 juvenile felony and 10 probation violations. So he hasn't responded favorably while he was dealing with the juvenile system. The state obviously does not know how he will do at this point, but it is his first adult felony. Not speaking with probation, it did indicate that the defendant appeared to be willing to try different programs. So the state is not opposed to giving that opportunity. Obviously, if he does not take the opportunity, prison becomes back as a chance for him if he has a probation violation in this case. At this point, he has 67 days credit. So at this time, we would not oppose community control with additional jail time with the 67 days jail time credit. That he be placed into the jail treatment program, enter and successfully complete. That he be placed into the NeoCat program, successfully enter and complete that program. That he continue with mental health services to include regular psychotherapy and counseling. That he not use any drugs or alcohol, and he has periodic screens that come back negative. They have 1 doctor, 1 dentist, and 1 pharmacy, sign medical releases. That any medications that are prescribed, he takes only as prescribed. That he participate in an anger management course or classes, or counseling. That he engage in full-time work and or school. that he get either his high school diploma or his GED, that he get a license, that he engage in 12-step programming with a sponsor and a home group, that he has no contact with the corrections officer, that he pay restitution to her in the amount of $227.74, that he pays all costs and fees, and that he just realized that this is an opportunity that he can use to not come back to the adult system and to move on with his life, where he can return and look at the possibility of prison, which is obviously very different than the juvenile detention and treatments that he's had in the past. Thank you.
I've considered the record, the oral statements made, victim impact statement, and I didn't note that at the beginning. I did receive a written victim impact statement, the pre-sentence report, the comprehensive psychological evaluation, my conference in chambers with both counsel and probation officer, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden. I've considered the recommendations of the parties. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society and the victim, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I have considered all relevant factors, including the seriousness and the recidivism factors set forth in the statute. In that regard, there are factors that make the offense more serious. The victim suffered serious physical and psychological harm. The offender's relationship with the victim facilitated the offense. In terms of factors making the offense less serious, the court finds none. In terms of recidivism, there are factors making recidivism more likely. The offense was committed while in a detention facility. There is a previous history of juvenile delinquency as outlined by the prosecuting attorney. There's been a rehabilitation failure after previous delinquency adjudications and a failure to respond to juvenile probation. In terms of making recidivism less likely, the offender shows remorse. Under 29.13b1, there is no presumption in favor of community control because the offense was committed in the facility while being charged there or serving a sentence there. There is a I believe I saw a conviction for assault, correct, in his record?
Yes, Your Honor. As a
juvenile.
Juvenile, he had assaults in both 2018, 2019, 2018 to 2019.
All right. And there's no presumption for community control because there was a physical harm. There was a threat with physical harm with the prior conviction of physical harm. The defendant's ORAS score, the Ohio Risk Assessment Score, that is the state mandated risk assessment, was 36, which is high. Nonetheless, the defendant is young, and if he were a little bit older, I wouldn't use this as consideration, but I want to give him one chance as a young man to avoid prison, because that's going to really mess you up if I sent you to prison. You understand that? This is not juvenile detention. Prison has a lot older individuals there that will not be a good influence on you. And if I sent you to prison, you would come out much worse than going in. So I'm going to save punishment if you ever reoffend. But I'm going to give you a chance and consider this to be something that you regret and won't ever do again. I'm going to give you community control, placing you on it for a period of 3 years, subject to the general supervision and control of the Lake County Adult Probation Department under such terms and conditions that it finds appropriate. Among these, you shall not leave the state of Ohio without the permission of the court, and you shall abide by all laws, including but not limited to the laws related to firearms, deadly weapons, and dangerous ordnance. The court further imposes the following specific sanctions and conditions: a period of incarceration in a Lake County jail for 127 days with credit for 67 days already served, the last 30 days of which you shall enter, participate in, and successfully complete the jail treatment program and follow all aftercare recommendations. Immediately following completion of the jail treatment program and your stay in Lake County Jail, you're to be transported to enter, participate in, and successfully complete the Northeast Ohio Community Alternative Program, NEOCAP, in the city of Warren in Trumbull County, and follow all recommendations including aftercare. While there, you're to be supervised by the Trumbull County Adult Probation Department. Immediately following completion of NEOCAP, you're to be brought back to Lake County for an additional 60 days of transitional day reporting that can be reduced or eliminated based upon stabilizing factors in your life, including residence, employment, sobriety, and things of that sort. You're to have complete abstinence from alcohol and drugs of abuse, meaning no marijuana. Marijuana is illegal. Periodic screens to monitor your compliance. You're to attend a minimum of 2 12-step program meetings per week, have a sponsor, and be involved in a home group. You're to obtain your GED or high school diploma. You're to have full-time employment or school or combination of employment and school, but outside of any establishments that sell or purvey alcohol or drugs as the primary source of revenue. Pursuant to 2929.18, the court determines that you have or will have the ability to pay restitution to your victim, the amount of her out-of-pocket loss. The court orders restitution in the amount of $227.74 to the victim. Judgment for that amount to be paid in full at least 90 days prior to the expiration of the stated period of community control. You're to continue your psychological treatment, your psychotherapy, and follow all recommendations. You're to take all medicines as prescribed. You're to obtain your driver's license. You need a driver's license to work. You need to get your GED or high school diploma to get a better job. All of these sentencing conditions are intended to get you on the right track with psychological counseling and sobriety. You're to perform 100 hours of community service, have one doctor, one dentist, one pharmacy at any one time prescribing or filling prescriptions for you. You're to inform the adult probation department of any change in providers, sign medical releases so that they can monitor drug-seeking activity on your part. You'd have no contact with the victim in this case, and if they don't provide anger management counseling at NeoCap, you are to engage in and complete an anger management counseling regimen. You're to pay the costs of prosecution, confinement, community supervision, treatment, and court costs. The court will file with Leeds a Hopper Act notification. I explained when I took your plea the Hopper Act because I am ordering psychotherapy and you have a conviction for a crime of violence. This will put your name into the FBI computer. That's the same system that every police department in the United States uses. When they run your name, they're going to see you're a violent offender and you've been ordered to for a mental health condition to engage in psychotherapy. That means you might get special handling. You understand what I mean? So you have to watch yourself. You cannot let your anger get the better of you. You understand? That's only going to get you in trouble. A violation of this order will result in a prison term of 6 to 12 months. If you do end up in prison, post-release control is optional for up to 2 years. They'll give you rules. You violate their rules, they can return you to prison for up to 6 months in this case, even for one violation. All of that time is part of the sentence. Should the violation of post-release control be a new felony, the judge in a new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for another year. All of that time is already part of the sentence. While in prison, you may be eligible for, be offered, and be able to earn some credit against prison time to be served by engaging in programming offered to you for that purpose. The prison credit is normally 8%, but if I send you to prison before you obtain your GED or high school diploma, you might be able to stretch that to 10% by getting it there. So long as you are not serving a prison term, you may be able to substitute community service to pay off the costs of prosecution. You work it off at the rate of $10 per hour. Each hour of work performed reduces the judgment by that amount. That's in addition to the 100 hours I ordered as part of the sentence. So long as you owe any court costs, the state can block your motor vehicle license plates until they are paid in full. Bond is released. Is there anything further from the state?
No, thank you.
Defense?
Nothing else, yeah.
Probation? Mr. Gibson, do you understand what I have ordered you to do?
Yes.
You understand this is not juvenile. I meant every word of it. You understand it?
Yes,
All right. Good luck. We're adjourned. We're on the record. This is case number 18 CR 000617, State of Ohio versus Ernest E. Kinder. Mr. Kinder is in court, represented by counsel, Assistant Public Defender Ashlyn Carroll. On behalf of the Lake County Adult Probation Department is Officer Jennifer Naus. Mr. Kinder was here first on this case on February 11th of 2019. He requested intervention in lieu of conviction. I had him assessed by an appropriately licensed professional. I determined that he was eligible. I had reason to believe drug or alcohol usage was a factor leading to his criminal behavior, that intervention would not demean the offense. Intervention would likely reduce future criminal activity. Mr. Kinder told me he was willing to comply with everything I ordered of him. Based upon that representation, I granted his request for intervention. I stayed the criminal proceedings. He waived indictment, pled guilty to 1 count of possession of cocaine, felony 5, and a forfeiture specification. I ordered him to comply with an intervention plan which included 2 years of community control monitoring, 47 days in jail, credit for 2 days. I suspended the remaining 45 days so long as he entered within 7 days an intensive outpatient treatment program at the Lake Geauga Recovery Centers, completed that program following all recommendations and aftercare. He was to consider the opiate recovery program, and if he obtained the Vivitrol shots, follow all recommendations and aftercare. He was to have an initial mental health assessment and follow all recommendations, complete abstinence from alcohol and drugs of abuse, periodic screens to monitor his compliance. He was to attend 5 12-step program meetings per week, have a sponsor, and be involved in a home group. Have full employment or school or combination of employment and school. 1 doctor, 1 dentist, 1 pharmacy. Take all medicines as prescribed, and the forfeitures. He was to pay the costs of confinement, prosecution, supervision, treatment, and court costs. I told him a violation would result in a termination of the intervention plan, a finding of guilty, and 12 months in prison. I notified him of the potential and consequences for violation of post-release control. I reinstated his bond at personal, recalling a warrant. The defendant returned to the court 4.5 months later, June 24th of 2019, on a probation violation. He waived his probable cause and final hearings, pled guilty to 2 violations using opiates, heroin, and cocaine, and a fake urine. I terminated his intervention. I found him guilty of count 1, possession of cocaine, felony 5. I adopted a joint recommendation for community control, placing the defendant on 2 years of community control sanctions with 1 day in jail. Credit for 1 day as of that date. The overall credit as of that date was 3 days. I ordered him into mental health counseling, continue the Vivitrol injections at Lake Geauga. He was to reside at Lake House and follow all their aftercare recommendations through Lake Geauga. Abstinence screens, 5 12-step program meetings per week, have a sponsor, be involved in a home group, full employment or school, 1 doctor, 1 dentist, 1 pharmacy, take meds as prescribed, and other advisements. I told him a violation would result in a prison term of 12 months. I reiterated the post-release control admonition. The defendant returned to the court 4.5 months later, November 4th, 2019, on another probation violation. He waived his probable cause and final hearings, pled guilty to 3 violations associating with a person on probation, a technical violation using methamphetamine, a non-technical violation, fake urine again, non-technical violation. I extended his community control by 1 year to a total of 3 years. I imposed 49 days in jail, credit for 48 on the violation. The overall credit as of that date was 51 days. He was to complete the Thinking for a Change program, have monitored urine screens, and the court needed proof in writing of all 12-step program meetings. He was to do the relapse prevention program at Lake Geauga Recovery Centers. All other conditions remain as previously ordered. On June 24th of 2019, I reiterated a violation would result in a prison term of 12 months. I notified him of post-release control and the consequences for violation. The defendant told me at 5:10 p.m. and 9 seconds, "You will never see me again. If I'm not released today, I lose my job, my house, my family. I take full responsibility for my actions." He said at 5:16, "Throw the book at me if you ever see me again." Does this ring a bell? All these statements, I don't have to play them back for you, right? I told him any further violations will result in maximum imprisonment. The defendant returned to the court again on May 9th of 2022 on a probation violation. He waived his probable cause in final hearings, pled guilty to one violation, using marijuana and cocaine, a non-technical violation. I held sentencing. I extended his community control by 1 year to a total of 4 years. I imposed 32 days in jail, credit for 32. On the violation, the overall credit as of that time was 84 days. He was to have a new drug and alcohol evaluation and follow all recommendations in aftercare, a new mental health assessment and follow all recommendations, 4 12-step program meetings, not on Zoom, in person only. All other conditions remain except as previously modified on June 24th of 19 and November 4th of 19. I reiterated a prison term for 12 months would be the violation. I notified him of the post-release control advisements. The defendant returns to the court on another set of probation violations. The probation violations are documented in an affidavit signed by Officer Naus on July 13th of 2022. She alleges 2 violations. Rule 10 requires random urinalysis with a good sample. She says that on July 13th, 2022, the defendant submitted a urine sample which registered a temperature of 93.8. He was asked to submit another observed sample which registered normal temperature. When questioned, the defendant turned over a plastic bottle which had contained urine other than his own and admitted to using what he thought was heroin. Rule 8 requires sobriety. The officer says that the second sample with dipsticks tested positive for morphine, opiates, and fentanyl. The state of Ohio filed a motion to terminate community control. You're entitled to a probable cause hearing, the purpose of which is for the court to determine whether there's a reason to continue to hold you to answer for the violations. You're entitled to a final hearing whereby the court would require evidence to its satisfaction that you violated in either or both of the ways alleged in the officer's affidavit. And if I so find, you're entitled to a sentencing hearing. Do you understand these hearing rights? Have you discussed with your attorney the waiver of your probable cause hearing, the waiver of your final hearing, and a plea of guilty to the 2 violations and any other options you may have at this point.
I have, Your Honor.
You understand your exposure is that 12 months in prison that I was trying to get you to understand waited for you if you didn't comply.
I understand, Your Honor. I'm not a criminal. I'm an addict.
No, I know you are. You're an addict. And what can I do with you?
I want
You've
the
heard...
Vivitrol- I want the Vivitrol shot again.
Pardon?
I want the Vivitrol shot again.
How many Vivitrol shots have you had?
15.
15. You've had 15 shots.
And then the pandemic hit.
Now, and then the pandemic hit. Okay. And I can understand how a lot of the social services have dropped through because of the pandemic and the ill-advised lockdowns. I understand that. And people that made these lockdowns didn't understand that I deal with people like you every day, and when they pull the carpet out, then you folks go back to committing crimes, doing drugs, committing crimes to get money to do drugs. The problem here is you spent $15,000 just on the shots. That's money that you didn't pay, right? I just want to make sure the record is clear.
I have insurance.
Mr. Kinder, did you pay for the shots? Who paid for them?
My insurance did.
Your insurance paid for the shots. So $15,000 was the cost of those shots.
But I did
And
very well.
pardon?
I did very well during that time.
Well, why didn't you continue with the shots?
I can't give you an honest answer.
Did the shots take away the urge?
It took it all away. The urges.
Okay,
the
so it
dreams.
took the urge away. You were sober for that whole period of
Almost
time?
3 years, yes, almost 3 years, sir. And I thought I was strong enough to stand on my own. You know what? My problem is ego and arrogance. I'll be honest with you. And I thought I was stable. I thought I was good. I thought I could handle it. But I wasn't. And I'd been experiencing some problems with my bipolar medicine. And so I took it upon myself to stop taking it and became manic and spiraled out of control. And here I am.
And, you convinced me 2 times ago
I understand.
when I said, no more chances. That was
Your Honor,
the 3rd time before, and you'll never see me again. I've lost everything. Throw the book at me if you ever see me again.
Your Honor,
Yes.
I don't know if I have another recovery in me, but I know I have the relapse, and I don't want that. I don't know if I'm going to come back from that. I'm scared out of my mind that I'm going to be taken from my family, from my kids, my wife. They need me.
Well, what am I supposed to do with you?
Let me try the Vivitrol shot one more time. Just if you can just give me a stay of execution one last time.
I mean, this is what you told me 2 times ago.
I understand. You know what? And if you do, I would like to keep Miss Nouse as my probation officer. She's sharp. She's very intelligent.
Well,
I believe she cares.
Probationers don't get the choice.
Yeah.
That's the chief of that department determines
I'd like to apologize
who the
to her.
probation officer is.
I didn't extend her the respect that she deserves. Like I said, Your Honor, I'm not a criminal. I'm an addict. I haven't done any other criminal activity. I haven't stolen anything. I haven't done any grimy stuff, period. I haven't got caught any more charges or anything. I work hard. I'm a great machinist. I'm a great family man. I suffer from chronic pain. Okay? I have really a tore up back. I mean, I could show you a scar from my last back surgery. I just had it in October.
Why are you putting your family through this?
I'm an idiot. Quite frankly, I'm not this stupid. I'm just this sick, Your Honor. I'm an addict. I have been for the last 20 plus years. I'm trying really hard. I don't need to go to prison. I need to be able to work for my family and tried my recovery.
So, how long have you been sober now?
With this last mess up,
You're only sober since the last time you used. When was the last time you used?
the 13th.
July 13th. All right. So you've been sober now for 12 days because we kept you locked up.
Yeah. I want to go to Signature Health. If I'm released today, I'm not going straight home. I'm going to Signature Health and getting the Vivitrol shot before I go anywhere. I'm signing up for IOP. I'd sign up for counseling and get my bipolar meds back.
All right, tell you what, you're making me a lot of promises here, right? Okay, let me make you a promise. You bring in fake urine again, I'm going to refer the matter to the prosecuting attorney to take to the grand jury to indict you on felony 3, tampering with evidence, and obstruction of justice. You understand that?
Absolutely.
I will make that referral.
Thank you.
What the grand jury does is up to them, but you can't be bringing in false urine, fake urine.
I will not do it again. I panicked. I said I was in a bipolar manic.
But you've done this multiple times.
I have. I panicked. I got scared. I don't want to go to prison, Your Honor. My family cannot survive without me. I've got 2 kids in college and a partially disabled wife. I'm the breadwinner.
Do you think of them
No,
when
I don't.
you do the drugs?
No, I
No,
don't.
you don't. You just think of yourself.
I think of my pain. I think of my pain, Your Honor.
Well,
I
there's a
can
lot of
barely walk.
people in pain, and they don't do what you do. I understand your predicament. You're not the first one I've seen in this position. I understand that. But you can't continue violating the law in the way you're doing.
I understand that, but I'd really like one more try at it. And I understand that's absolutely unheard of. You've been more than graciously fair to me. But I believe that you see that I'm not a hardened, grimy criminal.
I know you're
And I'm
not.
someone that struggles with substance abuse issues.
All right, so you understand your options at this point. You understand the consequences are a maximum of 12 months in prison. You've discussed this all with your attorney, correct?
I have, Your Honor.
Do you give up the right to a probable cause hearing?
I do, Your Honor.
Do you give up the right to a final hearing?
I do, Your Honor.
What's your plea to the first violation, fake urine?
Guilty.
Your plea to the second violation, using the opioids?
Guilty.
Court finds that the defendant has knowingly, voluntarily, and intelligently waived his rights to a probable cause and to a final hearing, has entered a plea of guilty to the violation. Court finds the defendant guilty of the violation and determines that they are both non-technical violations because they would be crimes committed even by one who is not on probation. Jennifer, how long does someone have to have the opioid out of the system to avoid a violent withdrawal when they get the Vivitrol shot?
I believe once they test negative, once it's out of their system, I believe that they're able to get the shot.
So it's only a negative test?
I would believe so.
When you got the drug and alcohol evaluation in May, what did they...
I went there, I was sick, and so they rescheduled it, and then the guy went on vacation, so I wasn't able to get it done.
What about the mental health?
Same thing, the same guy was going to do it.
So there's only one guy that does this?
Yeah, Pete was supposed to do it at Lake Geogga. This is why, if I'm released today, I'm walking to Signature Health.
Well, I'm not going to let you walk there. You're going to be taken by a probation officer there.
Okay, that's fine.
They're going to watch you get injected.
Yes, absolutely. Thank you, Your Honor.
Your Honor, if I may. Signature Health has months of waiting time to put people into treatment at this point.
What about Lake Geogga?
Lake Geogga, if he's already done the intake, he could get in quicker, and they also do the Vivitrol shot. There's really no difference.
Yeah.
Okay, no, I don't care where it's done, but it needs to be done as soon as possible.
You may be able to do it, walk into Signature Health, but their IOPs are like 3 to 4 months back.
No, yeah, that won't
It's not
work.
helpful.
Everything's already done. That's all.
I've considered the record, oral statements made, pre-sentence report, drug and alcohol evaluations, my conference in chambers with defense counsel and probation officer, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I've considered the need for incapacitation, deterrence, rehabilitation, and restitution along with the public burden. I've considered the separate recommendations of the parties. I have reasonably calculated this sentence to achieve the 2 overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders, and using my discretion to determine the most effective way to comply with the purposes and principles of sentencing. I have considered all relevant factors, including the seriousness and the recidivism factors set forth in the statute. By the way, have you said everything you want me to know?
I have, Your Honor.
All right, and I didn't mean to cut you off, but
That's okay, Your Honor. You pretty much covered everything I would cover.
nothing's changed as far as the seriousness of the offense in terms of recidivism. The defendant persists in his criminal behavior, drug behavior, with the fake urine to mask his use of illegal drugs. All of that makes recidivism more likely. In terms of making recidivism less likely, he's sober now, and I believe him and his remorse, and I know he doesn't, and I know he's sincere when he says he doesn't want to live like this. I don't know what I don't know what's going to wake you up. I can't believe the pain you are putting your family through, and I feel for them, and I can't imagine what they're going through, and I can't imagine what you're going through. I understand that addiction is the most difficult thing. I'm going to give you another chance, and I know you're not a criminal, but you are doing criminal things by, you're getting your drugs from dealers, and that's a dangerous activity, and it's a criminal activity. But I'm telling you, you bring in fake urine, you try to hide your use from the court, then I've got no use for that. And I will refer all the fake urines to the prosecutor for indictment, not just the more recent one, the future one that may precipitate all this, but the two previous ones. You understand?
I understand, Your Honor.
And
I appreciate that.
if you go to prison for the fake urine, that's 3 years.
Absolutely.
Okay, it's only 12 months for using the drug, but it's 3 years for the fake urine. You understand?
Yes, I do. Thank you, Your Honor.
So I'm continuing your community control for the 4-year period. I'm imposing 25 days in jail, credit for 13 on the violation. Court notes the overall credit as of today is 97 days. You can be released to go with an adult probation officer to the Lake Geauga Recovery Centers to obtain a Vivitrol injection. They'll have to make the appointment, and they will take you at the time of the appointment, and when they do take you and you get the shot, then the balance of the jail would be vacated. But I'm not going to let you go on your own. All other conditions remain as previously ordered on June 24th of 19, November 4th of 19, and May 9th of 22. Jennifer, you want to see anything else ordered other than all the prior? A violation will result in a prison term of 12 months. If you do end up in prison, post-release control is optional for up to 2 years. They can return you administratively for up to 6 months, even for one violation. Should the violation of PRC be a new felony, the judge in a new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for another year. All of that time is part of the sentence. Anything further, Ms. Carroll?
No, Your Honor, thank you.
Mr. Kinder, I wish you the best of luck.
Can I shake your hand, Your Honor?
I don't do that.
Okay. Thank you so much.
But I understand your sentiment. We're adjourned.
All rise.
thirsty, hot.
I'm so ready.
I see that water.
I am so ready. That door's so lights out.
Well, I guess I opened that door.
Bobby, close that door.
Grandma, that's
Other people are coming.
Grandma, that was crazy.
Oh, you know what, Tony? You know in the hallway where Mike keeps the white rags that he gets from his work? How they're all the way against the back wall? The whole stack was on the floor. Mike's like, how did you get from there on the floor?
You know, as much as this does sound crazy, since Bobby's passed away, there's been times that I was laying in bed and all of a sudden like his name just popped up in my head, or like a memory of him, and then my whole body had to tell was crazy goosebumps. And I don't know about anybody else, but that's me, that's either God or him.
Well, I don't believe in spirits and ghosts and all that, but I'll tell you, something pushed open my front door.
Or you remember when I was telling you about my dream and someone stomped upstairs and there was nobody?
Nobody was there. Me and Bree were downstairs, and we heard this big stuff. Yeah, that's right.
Like stomping.
That's weird.
I'm so sad.
Why didn't we just go?
I wasn't allowed.
Oh, that's
They
right.
kept me out of it.
That's right. Yeah, you should have just broke out. I'm kidding. I'm kidding.
Why didn't you
Hey,
just...
that's me in jail.
I'm kidding.
They want you to go to jail.
Just the fact that you said, why didn't you just go? Like, you just
I
go.
know.
Hey, great, both of you guys, because we're on lockdown, so I don't know if I'm going to call you. If they approve it, I'm going to treatment at 8 a.m. tomorrow, and I will not be calling you guys for the month.
Oh, I'm so sad. She calls me 100 times a day. She's not with Bill.
No, I picked her up. She's been talking since she hasn't stopped talking.
She is a
Okay.
and she's real high pitched. Did you notice that?
Guys, I'm nervous. I'm sick of my stomach right now.
She hasn't stopped talking all day. Say that to me, I can't.
Your hair looks good.
Good.
Guess I got caught wearing it.
Jada,
That's what she thought.
stop being better.
Where did we go the other day where someone asked, do you brush your hair? Someone asked him, do you brush your hair?
He said, oh, we weren't there last time. He said, I wish I
Guys, I was like, I had a bunch of clean yesterday.
Good.
I feel good. My body still aches, and sometimes I still get the electricity in my body when I'm trying to go to sleep at night. It's not every night now, but yeah. Breathe. Stop it. But yeah, some nights I still get the electricity in my body. I can still no about to. But that's just those. Say hi to Tabby. Say hi, Tabby. She's been missing.
Hey, did she tell you that I have eaten the well in the parking lot? She didn't see what I wanted. I thought it was sprayed in it. She just kept on going.
She probably didn't. She probably
No, she did, because her boyfriend goes, you hear that? She probably didn't know who it was. She turned around.
Tabby's real awkward.
She did.
Real weird. Yeah.
Why did you think you were stranded? Because I thought Mike left me there. What, honey? What? Oh, I don't know. No clue. See what you see here. It's everything. Where do you go?
I'm gonna need you
This is case number 21 CR 001283, State of Ohio versus Kayla K. Anderson. Ms. Anderson is in court, represented by counsel. Assistant Public Defender Daniel O'Connor, representing the State of Ohio's Assistant Prosecuting Attorney Rocco DiPiero. The defendant was here on June 27th, 2022. She waived indictment, pled guilty as charged. 1 count of telecommunications fraud, felony 5. I referred her for a pre-sentence investigation and report, set sentencing for today, and continued her bond as revoked. I have received a pre-sentence investigation report dated July 6, 2022, a drug and alcohol evaluation with a brief mental assessment prepared by Dr. Rinsberg, the court's forensic psychologist, dated July 18th, 2022. I've received a letter from Lake Geauga Recovery Center's intake department dated July 18th, 2022. I've read these documents. I will make them part of the record. Are there any inaccuracies or any modifications needed to the PSR?
No, Your Honor.
And the PSR shows 35 days of jail time credit. Both sides agree, 35 days, or do you have a different figure?
That's what I had, Your Honor.
Yes, Your Honor.
All right. Any reason not to proceed?
Your Honor, we're prepared to proceed today.
Go ahead.
Thank you, Your Honor. Your Honor, Kayla, during this case, from the very beginning, recognized that she needed to get help. She had spoken to the officers investigating the matter, and while it's been a path getting there, she recognizes that she needs help and is, during this time that she's been incarcerated, gotten into the right mindset, I think, to succeed in that path. We have a bet. We'd be asking for community control. We believe it is appropriate to the fact that this is her first offense as an adult. It's not an offense of violence. The fact that she's shown remorse for her actions and recognized the harm she could have put herself in when she put herself in this situation. Kayla, since the very beginning, has been talking to me about wanting to do treatment, and I believe that she is at a state where she can succeed in that manner. We have a bed available for tomorrow at 8:30 in which TJ Wyman would be able to transport her to. If the court granted that, we'd be asking that she be sent to Nevaeh Ridge. We believe that it's the appropriate place for her to seek treatment due to the fact that her mother had gotten treatment there and has been sober for the past 4.5 years. We believe that because of that, there's a trust in the system, seeing someone succeed through their program, that Kayla now sees that, hey, I can do this too. My mom was able to do it, I can do it. Kayla, over these past 35 days, has improved remarkably, and I think is in the right mindset when she spoke to me without my prompting that even whatever treatment the court deemed appropriate, that she thinks that being in sober living afterwards would be appropriate for her, so that she's able to avoid any bad influences in order to avoid any possibility of relapse. Kayla, I think, has a lot of potential. She's a very smart girl, and I think that by having her go through the Nevaeh Ridge program, that not only will she succeed, but she'll be able to successfully complete probation and stay sober. Thus, we believe that that is appropriate in regards to sentencing.
Kayla Anderson, the law allows you to say whatever it is you want me to consider before I sentence you. What do you want me to know?
After sitting here for the last 30 days, I think my eyes have opened and I have became in a whole entire different mindset that I don't think I ever would have reached without this coming to what it did. Me sitting here for 30 days and having to hold myself accountable for the actions that I had made, and realizing the severity of what I did. So with that, I just ask that I have the opportunity to go to treatment, and will show to you guys how much I really want it. That's all.
Let me hear from the state.
Thank you, Your Honor. Now, the state is going to join in the recommendation for community control sanctions in this case. I've spoken many times with investigating Detective Christian Caroon from the East Lake Police Department. And one thing's very clear. This could have been a very, very dangerous situation for the defendant. It turns out that a person that was contacted over the phone is somebody who was working with the police, and therefore there was no danger to the defendant or any of the people she was with at the time of that contact. Could have just as easily been that it was with a stranger, with no police, and she could have gotten hurt. And in speaking with Detective Caroon, he felt very strongly that the defendant needs drug treatment, and supported that thought and that idea as a sentencing. And so my point, I guess, in mentioning that is that the defendant has her family on her side. The investigating detective is even pulling for her. I hope that that thought keeps her from using drugs when she's alone and she thinks she can't help it. The state asked for a voluntary forfeiture of a knife that was recovered incident to this investigation, and joins in community control, credit 35 days. Thank you.
You have your high school diploma, correct?
Yes, sir.
I've considered the record, the oral statements made, the pre-sentence report, victim impact, the drug and alcohol and psychological evaluations, my conference in chambers with counsel and probation, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden on governmental resources. I've considered the joint recommendation of the parties for a community control sentence. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I have considered all relevant factors, including the seriousness and the recidivism factors set forth in the statute. In that regard, there is a factor that makes the crime more serious, the fact that it was committed as part of an organized criminal activity. There is a factor making the crime less serious. The victim induced or facilitated the offense. In terms of recidivism, there are factors making recidivism more likely. Defendant has a previous history in juvenile court with a significant number of violations, probation violations. There's been a rehabilitation failure after the delinquency adjudication. In terms of making recidivism unlikely, defendant has no criminal convictions and is genuinely remorseful. Under 29.13b1, there is no presumption in favor of community control because of the organized aspect of the criminal activity. Despite that, the court believes that the defendant is amenable to an available community control sanction based upon her age. Community control is appropriate. Defendant is 19 years old. Her risk assessment score is in the moderate range of 26. The court will impose a period of community control for 3 years, subject to the general supervision and control of the Lake County, Ohio Adult Probation Department under such terms and conditions that it finds appropriate. Among these, you shall not leave the state of Ohio without the permission of the court, and you shall abide by all laws, including but not limited to the laws related to firearms, deadly weapons, and dangerous ordnance. The court further imposes the following specific sanctions and conditions. You're to serve 37 days in a Lake County jail, credit for 35 days as of today. You're to be released tomorrow to be transported to Nevaeh Ridge, enter, participate in, and successfully complete its program, follow all recommendations, including aftercare, and the balance of the jail would be vacated. Immediately following completion of Nevaeh Ridge, you are to go and live in a sober living facility for at least 6 months. You'd have complete abstinence from alcohol and drugs of abuse, periodic screens to monitor your compliance. You're to attend a minimum of 4 12-step program meetings per week, have a sponsor, and be involved in a home group. You're to consider medication-assisted treatment, specifically Vivitrol, not Suboxone or Methadone, if recommended, and follow through, including aftercare. You're to have full-time gainful legitimate employment or school or combination of employment and school, but outside of any establishments that sell or purvey alcohol or drugs as the primary source of revenue. You're to obtain or continue your mental health counseling services. One doctor, one dentist, one pharmacy at any one time prescribing or filling prescriptions for you. You're to inform the adult probation department of any change of providers, sign medical releases so that they can monitor drug-seeking activity on your part, and you're to inform your providers of your addiction. You're to take all medicines as prescribed and perform 100 hours of community service. You're to have no contact with Megan Bacon. You're to forfeit all contraband and instrumentalities, pay the costs of prosecution, confinement, community supervision, treatment, and court costs. A violation of this order will result in a prison term of 6 to 12 months. If you do end up in prison, you may be able to earn credit capped at 8% of time to be served by engaging in programming offered to you for that purpose. Upon your release from prison, you could be on post-release control in the discretion of the Ohio Adult Parole Authority for a period of up to 2 years to give you rules. You violate their rules, they can return you to prison for up to 6 months in this case, even for one violation. All of that time is part of the sentence. Should the violation of post-release control be a new felony, the judge in a new felony case, in addition to sending you to prison on a new case, can send you back to prison on this case for another year. All of that time is part of the sentence. So long as you are on community control, you may be able to substitute community service to pay off the cost of prosecution, working it off by local rule at the rate of $10 per hour. Each hour of work performed reduces the judgment by that amount. That's in addition to the 100 hours I ordered as part of the sentence. So long as you owe any court costs, the state can block your motor vehicle registration, your license plates, until they are paid in full. Bond, if any, is released. Anything further from the state?
No, Your Honor. Thank you.
Defense?
Your Honor, I think the only thing I could think is that her phone during the duration of the case was seized. We just asked that it be able to be released to her family.
The phone may be released to family. I don't believe you're allowed to have a phone at Nevaeh Ridge.
Your Honor, she would more just so that they have her former sponsor on contact so that she'll be able to get that phone number, but she understands she won't have her phone while at Nevaeh Ridge.
Okay, so who in the family would it be released to?
Her mother.
Kristen Anderson.
What's the name again?
Kristen,
K?
K-R-I-S-T-I-N.
K-R-I-S-T-I-N?
Yes, Anderson.
All right. Megan, anything further? Sanderson, do you have any questions of what's expected of you, my order?
No, Your Honor.
All right. Good luck. We're adjourned.
All right. Thank you.
Bye, Kayla. Goodbye, Kayla.
You're welcome.
All rise. The common police for Lake County is now in session. The Honorable Eugene and Lucci presiding.
May be seated. We're on record. These are case numbers 22 CR 000187 and 22 CR 000469. Both cases, State of Ohio versus Bonnie T. Davis. Ms. Davis is in court, represented by counsel. Assistant Public Defender Lauren Tuttle. Representing the State of Ohio is Assistant Prosecuting Attorney Kara Salim. Ms. Davis was last here on June 28th, 2022. She waived indictment on both cases, pled guilty as charged in the 187 case of count 1, possession of cocaine, felony 5, and a forfeiture specification for contraband and instrumentalities. In the 469 case, she pled guilty to count 1, possession of drugs, felony 5, and a forfeiture specification. Count 2, operating a vehicle under the influence of alcohol or drug of abuse or a combination of them, misdemeanor 1, and a forfeiture specification. I referred her for a pre-sentence investigation and report and set sentencing for today. I maintained her bond revocation on the 187 case. I set it at own recognizance on the 469 case. I have received a pre-sentence report prepared by the Lake County Adult Probation Department dated July 18th, 2022. I've received a drug and alcohol evaluation with a brief mental assessment prepared by the court's forensic psychologist dated July 21st, 2022. I have received a letter from the defendant from the jail dated June 19th, 2022. A letter of character reference from Mary Ann Ojnik dated July 13, 2022, and an email from Kevin Ellis from Lake Area Recovery Center. I have read these documents. I will make them part of the record. Are there any inaccuracies or any modifications needed to any of these documents?
Your Honor, just the jail time credit as discussed in chambers, it should read 70 days jail time credit on case 187.
All right. So both sides agree that it's 70 days credit on the 187 case, 2 days credit on the 469 case, correct?
Yes, Your Honor. Yes.
All right. Any reason not to proceed?
We're prepared, Your Honor.
Go ahead.
Thank you. Your Honor, Ms. Davis understands the severity of the situation that brings her before you today. She understands the complicated mess that is before the court right now. And I think what upsets her most of all is that she fully understands that the reason she's here is of her own doing. Bonnie has had an incredibly rough past 2 years. She went through 6 years of sobriety from 2014 to 2020. And in 2020, she suffered from a relapse. It's a relapse that she hasn't been able to get back out from underneath. It's something that has kept her down. It's something that I know more than anything she wants to get better. She wants to be sober, and she doesn't want to live life the way that she's been living for the past 2 years. That relapse led to the case that she's on probation in Florida for. It led to the OVI that she picked up out of Menor, and it led to the 2 cases that are before the court right now. I know that Bonnie is disappointed in herself. She's disappointed that she has not been able to do this on her own. More than anything, she wants to go back to treatment. She wants to regain her sobriety. She wants to use the tools that she has and to gain new ones in order to be successful. Bonnie has lived long periods of her life sober, and I know she feels the most like herself when she's not using drugs. The past 70 days she spent in the Lake County Jail have really been a wake-up call for her. She understands the complexity of her situation and that there's not a holder on her yet from the state of Florida, but that likely one would shortly follow after the sentencing hearing here. She understands the implications for her case there and the fact that she has suspended time hanging over her head. There are a number of different factors that are complicated at home. Her husband recently fell off a roof and is in a rehab facility. She has 3 children. They are older, but I know that they do still need their family present with them, and that's a bit difficult right now. Bonnie understands that she has to take care of herself and these cases before she can return to her family. She would ask that the court consider community control sanctions here, consider the opportunity for treatment, whether that be the jail treatment program or treatment at New Beginnings. They would accept her at that program, as Your Honor is aware from the email provided to the court. If this is too complicated, too difficult, the court cannot find that she's amenable to community control sanctions, Bonnie would request a prison sentence in the 6 to 9 month range. It would adequately address her conduct here, it would provide punishment, and it would give her the opportunity to go to Florida to resolve the matters that she has pending there as well, without being tied up here for an extremely long amount of time. As far as the OVI is concerned, we would request a minimum fine here of $375 as Bonnie is indigent, and a minimum license suspension of 1 year. She did have insurance at the time of the motor vehicle accident and believes that that should help with any restitution. I don't know if any was requested from the other driver, but she did have insurance. So if that was not shown as proof before, she would get proof to the court in order to make the victim whole here.
Well, the victim was complaining that she couldn't get any information.
Okay. Well, Ms. Davis will be more than willing to work with the other individual here to provide her insurance information. Thank you.
Bonnie Davis, the law allows you to say whatever it is you want me to consider before I sentence you. What do you want me to know?
That my actions were immature and reckless. And then I'm just very lucky that I myself or somebody else wasn't hurt in the process of my behaviors. And I was out of control.
So what makes this time different from all the other ones? This is your third OVI.
My third? Oh.
You forgot about it?
I did.
Yeah, this is your third OVI. You have, you've been sent to prison. The judge graciously gave you judicial release, and then you violated after you got out of prison when he put you on probation, right?
I completed probation. Oh, okay. Yeah, you're right.
Okay.
I did.
If I'm wrong on that,
No, you're right.
let me
You're
look
right.
it
I
up,
remember-
because you're
no.
contradicting everything
No,
I'm saying.
Probation did say yes. She did tell me. It was 2014, yes. You're
Okay.
right.
I mean, I hope it's not that you've had so many of these you can't even
No.
keep track.
I did not remember.
And how long has Florida been looking for you?
Looking for, what do you mean looking for?
Your Honor, there was never a violation filed. There were two.
Isn't there a warrant
two sanctions.
outstanding in Florida?
No, Your Honor, there's not a warrant outstanding. Her probation was transferred to the APA. Here, I have been in contact with Officer Downs. He has filed 2 sanctions for her to do treatment, neither of which have been completed.
For Florida?
It's through her Florida case that was transferred up here. So he is with the Ohio Adult Parole Authority.
Right, but Florida has to handle that because she committed the crime in Florida.
Yes, Your Honor.
So even though it's an Ohio officer, the officer is performing courtesy supervision for the state of Florida.
Yes, Your Honor.
All right. So the Florida violation relates back to the date of this violation, these violations here, correct?
Yes, Your Honor. It dates back to the first offense in these cases, and then the second and the OVI that she has in Muni Court as well. After speaking with Officer Downs, it's my understanding that Florida intends to pursue this after the defendant is sentenced in these present cases, Your Honor.
All right, and that's on the cruelty towards child.
That's correct, Your Honor.
And Euclid Municipal wants her too.
She does have a failure to appear warrant from Euclid Municipal Court for traffic case 22 TRD 00551.
So, Ms. Davis, continue with what you want me to know before I sentence you.
Because it's it. I mean,
That was it?
just ashamed. I'm embarrassed. I don't know what else to say.
Okay.
I just.
Let me hear from the state's attorney.
Thank you, Your Honor. The state is recommending 7 months on each felony case to be served consecutively, plus the requirements for the OVI of at least 3 days in jail, a fine of between $375 and $1,075, and a license suspension between 1 and 3 years. The
The presumption for community control in these cases has been overcome. The defendant has been on probation before, and she has shown that she is not a good probationer. According to the probation officer in Florida, she hasn't yet completed any of the conditions. In that case, she has received 2 written sanctions from the adult parole authority based on that. She has been given opportunities for treatment, and she has not complied. In her 2012 case, she failed to complete treatment then. She has failed to complete treatment that was ordered in her Florida case from 2020. She was sentenced in that case on 4/20/21. The 2 written sanctions, she was ordered to complete treatment in both of those and has not done so. She was not honest during her interview with probation. She gave a completely different story about what happened in her Florida case, and she was reluctant to give an accurate account of what substances she had been using since her relapse. Dr. Rinsberg also noticed the inconsistencies in her stories. She has a history of probation violations and failure to appears. Parole Officer Downs from the Ohio APA, who has her courtesy probation from her Florida case, believes that they are spinning their wheels with her and that there isn't really anything more they can do. He believes that prison is an appropriate sentence. She also presents a safety concern to the community. She picked up 3 new cases within 3 months. The second 2 cases were both OVIs with accidents. Those occurred within 10 days of each other. She was on probation when picking up these new cases, and she was out on bond from the first case when she picked up the 2 OVIs. In her Florida case, she groped a teenager and attempted to pull a toddler under the water. And while she's not being sentenced on that case, it just shows her, it demonstrates how much of a public safety concern that she is. Because she's clearly unable to control herself, and despite being given numerous opportunities, she continues to present as a danger to the public. So the state recommends 7 months on each of her cases to be served consecutively, as well as the mandatory OVI requirements, Your Honor. Thank you.
And despite the victim of the OVI not being able to get information, is there a restitution request?
Not to my knowledge, Your Honor. In this case, I don't believe he was able to obtain the insurance information, but it is my understanding that Ms. Davis did have insurance.
Okay, so you can go through his underinsured motorist, and then they can pursue the insurance.
Yes, Your Honor, that's my understanding.
There's a holder on her from Florida, correct?
Not yet, Your Honor.
Not yet.
Not yet.
I've considered the record, the oral statements made, the pre-sentence report, drug and alcohol and psychological evaluations, my conference in chambers with counsel and probation, and statements of the defendant and a defendant's counsel. I've also considered the overriding purposes of felony sentencing pursuant to Revised Code 2929.11, which are to protect the public from future crime by this offender and others similarly situated, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden. I've reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society and the victim, and to be consistent with sentences imposed for similar crimes committed by similar offenders, in using my discretion to determine the most effective way to comply with the purposes and principles of sentencing. I have considered all relevant factors, including the seriousness and the recidivism factors set forth in Divisions B through E of Revised Code Section 2929.12. And just so the record is clear, none of these charges merge with each other. In terms of seriousness, there are factors that make the offenses more serious. The defendant has two prior OVIs, and that speaks also to recidivism, but the defendant's behavior shows that she is out of control. There are no factors making the offenses less serious. In terms of recidivism, the offenses were committed while on community control sanctions out of the state of Florida, and the 469 crimes were committed while on bond on the 187 case. Defendant has a previous criminal history. Which includes some minor charges as an adult: contempt of court, disorderly conduct in Eastlake and in Euclid, then drug possession, felony 5 in Cuyahoga County. She was in the early intervention program and violated by using cocaine. She was ordered to complete inpatient drug treatment and comply with all aftercare. She failed to appear for a probation violation on that. She was ordered to complete a 90-day program at the Community Assessment and Treatment in Cuyahoga County, CATS. Then there was another violation. She didn't complete CATS. She took illegal drugs. The judge there terminated the early intervention program, imposed 9 months in prison. Defendant was released early, given 1 year probation. She violated that with a new offense in Mentor and consuming alcohol. The new offense in Mentor was disorderly conduct. Then in Florida, cruelty towards a child. She was given 5 years of probation. The supervision was transferred to Ohio. Because of the crimes here, there's a violation noticed in Florida, but Florida can't do anything until the defendant is sentenced here. None of her conditions in the Florida case were completed. There has been and she has an OVI in Mentor while on bond here. And she was sentenced to 3 days on that with 12 months of probation and a fine. She's got a number of failures to appear in her record. She's had opportunities for treatment and did not complete or did not avail herself of it. She has shown that she cannot follow through on probation. She was deceptive in her interview with the probation department. And as the prosecutor mentioned, there are safety concerns with her. She's not genuinely remorseful. There's a pattern of drug or alcohol abuse, and the offender refuses to acknowledge a problem or accept treatment or apply treatment tools previously given to her to the extent that she availed herself of treatment. There's a failure to respond to probation. Court determines that the defendant is not amenable to any available community control sanctions, and that prison is needed to protect the public. Under 2929.13b1, there is no presumption in favor of community control here because of the prior prison, because the crimes were committed while on community control, because 2 of the crimes were committed while on bond on the first case. Court determines that prison is needed to protect the public, that a minimum sentence would demean the seriousness of her conduct. Court also determines that consecutive sentences are necessary to protect the public and to punish the offender. Consecutive sentences would not be disproportionate to her conduct and the danger she poses, and that the crimes were committed while on under a sanction, and her criminal history shows that consecutive terms are needed to protect the public. Accordingly, the court imposes a period of incarceration in state prison. On the 187 case, count 1 for 7 months with credit for 70 days. On the 469 case, count 1, 7 months with credit for 2 days. On count 2, 30 days with credit for 2 days. Counts 1 and 2 on the 469 case are concurrent, but the prison term on the 187 case is consecutive to the prison on the 469 case. So the total is 14 months with credit for 72 days. On the OVI, I'm imposing a fine of $375 and a license suspension of 2 years. On all counts, you're to forfeit all contraband and all instrumentalities, pay the cost of confinement, prosecution, supervision, treatment, and court costs. Upon your release from prison, you could be on post-release control in the discretion of the Ohio Adult Parole Authority for a period of up to 2 years. They can return you to prison for up to 7 months, even for one violation. All of that time is part of the sentence. Should the violation of post-release control be a new felony, the judge in a new felony case, in addition to sending you to prison on a new case, can send you back to prison on these cases for the greater of 1 year or whatever length of time remains unexpired on that potential 2 years of post-release control. All of that time is already part of the sentence. You may be able to earn credit capped at 8% of time to be served by engaging in programming offered to you for that purpose. So long as you owe any fines and court costs, the state can block your motor vehicle license plates until those are all paid in full. The court opposes shock incarceration or intensive prison program. You are under a firearms disability whereby you cannot purchase, own, possess, or use firearms or ammunition for firearms. That's both state and federal. You cannot vote from prison. You would have to re-register to vote upon your release from prison in order to gain the ability to vote. You cannot hold any position of public honor or trust. Bond, if any, is released. Is there anything further from the state?
No, Your Honor, thank you.
Defense?
No, thank you, Your Honor.
Anything from probation?
No, Your Honor.
All right, good luck. We're adjourned.
All rise.
Okay. So you gotta get there first.
All right, she's gonna talk. She's gonna talk to you.
We're on the record. This is case number 21 CR 001251, State of Ohio versus Carmen V. De Niro. Mr. De Niro is in court, represented by counsel, Assistant Public Defender Conchetta Ragazione. Representing the State of Ohio is Assistant Prosecuting Attorney Sarah Haranek. Mr. De Niro was last here on June 14th, 2022. He pled guilty to count 3, unauthorized use of a vehicle, felony 5. Counts 1 and 2 will be dismissed upon completion of sentencing. I referred the defendant for a pre-sentence investigation and report, set sentencing for today, and continued his bond. I have received a pre-sentence report prepared by the Lake County Adult Probation Department dated July 21st, 2022. I've received a drug and alcohol evaluation with a brief mental assessment prepared by the court's forensic psychologist dated July 20th, 2022. I have received a victim impact statement. I left that in chambers. The pre-sentence report shows a credit of 2 days to date. Do you agree with that, Ms. Ragazione? And any inaccuracies, any modifications needed to the PSR?
No, Your Honor.
Any reason not to proceed?
No, Your Honor.
You may address the court first.
Thank you, Your Honor. Your Honor, this case arose out of Mr. De Niro succumbing to his drug addiction. He did take the truck in this situation and use it beyond what he was supposed to be doing with it. He instead took the truck and used it to get drugs in Cleveland. He feels remorseful about this. He feels ashamed, as he expressed in his pre-sentence report. In his version of events, he explained that he has no excuse for this behavior. He does acknowledge he has a drug problem. He wants to stay sober. He is attending AA meetings. He has a sponsor through AA, and he is working full-time. He wants to continue to keep working so that he can make any restitution that needs to be made in this matter and continue on in his sobriety. He did test negative at probation when he came in for his pre-sentence report, both times that he went to probation. He does feel that the structure of the Lake County Adult Probation Supervision would assist him in being successful in his sobriety and in continuing to move forward and to deal with this situation that has occurred. He is working for Brandon Ansell Roofing. He's working 12 hours a day, 5 to 6 days a week. And he's also doing AA meetings, like I had mentioned, 1 to 2 times per week. His wife, Margaret De Niro, is here in the courtroom, and she was explaining to me that they have just recently been able to get their house out of foreclosure proceedings. They're on a probationary payment period where they have to be able to make their payments on the first of every month. They've been in this home for 17 years.
and she expressed to me that this was actually her childhood home where she grew up. So it's very important to both of them that they be able to maintain their household. Mrs. De Niro does work, however, she also needs financial support from her husband. She has her own health issues. So I am asking the court on behalf of Mr. De Niro to find him amenable to community control sanctions in this matter so that he can continue on in his sobriety and continue to move forward. His wife, Margaret De Niro, does wish to address the court as well. Thank you.
All right, let me hear from Mrs. De Niro first. Ma'am, if you'd come up to the podium, please.
Okay.
And would you state your name, please?
My name's Margaret A. De Niro.
M-A-R-G-A-R-E-T?
Correct.
Middle initial A?
Yes.
And you are Mr. De Niro's wife?
Correct.
And what do you want me to know, ma'am?
I just want you to know, when Carmen's not using, he's the best guy on earth. He'd give you the shirt off his back. That truck he stole, he cleaned out that guy's entire house, moved it all 4th of July weekend, and then made one mistake, as usual, the wrong mistake. But it's just, the fact is that if he goes to jail, I lose the house. And I need his monies to help me out. I don't make a lot of money, but not enough money.
Okay.
I mean, yeah, I've been dealing with this a lot of years, and I understand, he did bad. But, he's been doing very well. He's been helping me, taking care of the house. And I was hoping we can, keep that up and not lose the house.
All right, thank you.
Thank you.
Carmen De Niro, the law allows you to say whatever it is you want me to consider before I sentence you. What do you want me to know?
I accept the responsibilities for what I done. I know it was wrong. Me and Joe were friends for years. Before his wife died, I'd cut their grass, shovel their driveways in the wintertime, and I feel very bad for what I did because he passed away not too long after that. And I know it was wrong. I regret it, but I've had long stints of sobriety. Well, one long stint from 2006 to 2014. I sober 8 years. And then my son got cancer, and I used that for an excuse to pick up, and been battling with it. I don't know if I could get a year or.
How long have you been sober?
Now, about 6 months. Not that quite that long, but I still have. I've had the same sponsor for the last 9 years. I talk to him all the time. He's a good friend of mine.
So you've been in AA
since
for a long time?
96.
All right.
It took me 10 years to get a year, but.
Is there anything else you want me to know?
No, I won't. If I ain't using, I'm a halfway decent person, and it's when I pick up,
Let me hear from the prosecutor.
Thank you, Your Honor. The defendant does have a lengthy criminal history, as well as a self-reported intense addiction and 2 prior prison numbers. However, due to the fact that the majority of the defendant's criminal history was quite some time ago, along with the fact that Dr. Rinsberg stated with treatment his prognosis was fair, the state is willing to give Mr. De Niro one chance and ask for community control with JTP, and then
court-ordered drug treatment after his release. Thank you. As well as, I apologize, Your Honor, and I'm not sure if the court received it. I just received today, there was some mix-up. There was a victim impact statement from Penske as well. I gave that to the court 20 minutes prior to this hearing.
The Penske one, that's $1,269.53,
yes.
right? And was there another a second request for out-of-pocket? No.
No.
Okay.
I just wanted to make sure that the court
All right,
did
that's the
receive
one
that.
I was referring to.
Okay, thank you.
That I got. I've considered the record, the oral statements made, victim impact statement, pre-sentence report, drug and alcohol and psychological evaluations, my conference in chambers with counsel and probation, and the statements of the defendant and the defense counsel. I've also considered the overriding purposes of felony sentencing, which are to protect the public from future crime by this defendant and others similarly minded, and to punish the offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden. I've considered the joint recommendation of the parties for a community control sanction. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of the offender's conduct and its impact on society and the victim, and to be consistent with sentences imposed for similar crimes committed by similar offenders, and using my discretion to determine the most effective way to comply with the purposes and principles of sentencing. I have considered all relevant factors, including the seriousness and the recidivism factors set forth in the statute. In that regard, there is a factor that makes the offense more serious. The victim suffered serious economic harm. There are no factors making the offense less serious. In terms of recidivism, there are factors making recidivism more likely. Defendant does have a criminal history, a significant number of contempts of court. There were probably failure to pay fines for the most part. Defendant does have a pending case, theft case out of Rocky River. He's been to prison twice before, once in '92 and once in 18. He's had several prior drug and alcohol treatment attempts. The court determines that there's a factor making recidivism less likely. His family's dependence upon him being productive and working. Under 2929.13b1, there is no presumption for community control because of the prior prisons. Court determines that the defendant is amenable to an available community control sanction. The court will adopt the joint recommendation. The court hereby imposes a period of community control for 2 years, subject to the general supervision and control of the Lake County, Ohio Adult Probation Department under such terms and conditions that it finds appropriate. Among these, you shall not leave the state of Ohio without permission of the court, and you shall abide by all laws, including but not limited to the laws related to firearms, deadly weapons, and dangerous ordnance. The court further imposes the following specific sanctions and conditions: a period of incarceration in a Lake County jail for 62 days with credit for 2 days. The remaining 60 days are suspended so long as you enter, participate in, and successfully complete an intensive outpatient treatment program within 75 days. Kim, that's possible, correct? Based upon the availability of Lake Geauga?
Yeah, that's possible.
So if you complete the IOP, and it takes normally 30 days to get through that, and there should not be a waiting period to get into it. I'm keeping you out of jail so you can work. If you don't, then the 60 days that I suspended will be imposed. Understood?
Yes, sir.
You're to follow all recommendations, including aftercare, complete abstinence from alcohol and drugs of abuse, periodic screens to monitor your compliance. You're to attend a minimum of 3 12-step program meetings per week, have a sponsor, and be involved in a home group. You'd have full-time gainful legitimate employment. Pursuant to 2929.18, the court determines that you have the ability to pay restitution to your victim, the amount of the victim's out-of-pocket loss. The court orders $1,269.53 to be paid to the victim. Victim is Penske, correct?
Yes, Your Honor.
Judgment for that amount to be paid in full at least 60 days prior to the expiration of the stated period of community control. You're to take all medicines as prescribed, have no contact with the victim, pay the costs of prosecution, confinement, community supervision, treatment, and court costs. A violation of the order will result in a prison term of 6 to 12 months. If you do end up in prison, post-release control is optional for up to 2 years. They'll give you rules. You violate their rules, they can return you to prison for up to 1/2 the original prison term for any one violation or for all of them in the aggregate. If the violation of post-release control is a new felony, the judge in a new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for another year. All of that time is part of the sentence. Should you end up in prison, you may be able to earn credit capped at 8% of time to be served or a certain number of days by engaging in programming offered to you for that purpose. So long as you are not serving a prison sentence, you may be able to substitute community service to pay off the costs of prosecution, working it off at the rate of $10 per hour. Each hour of work performed reduces the judgment by that amount. So long as you owe any court costs, the state can block your motor vehicle license plates until they are paid in full. Is there anything further from the state?
No, Your Honor.
Defense?
Your Honor, we would just ask that bond be released.
Bond is released. Kim, anything from probation?
When you say that you wanted him to complete the ILP program, you said within 75 days, is that when you want it completed by or started by?
No, I want it completed by. But it's normally a 30-day program, right?
ILP usually lasts for 12 weeks.
But doesn't that include aftercare? No, that's without aftercare.
That's 8 to 12 weeks for aftercare. Then aftercare is for 12 weeks.
Okay.
Once a week.
All right. So then, then I want it completed within 140 days. Does that fit what Lake Geauga does?
That would definitely fit. You would have time to complete it by that time, Your Honor.
Okay. Mr. De Niro, do you have any questions about what my order is?
No, sir.
All right, good luck. We're adjourned.
Thank you.
Thank you, Your Honor.
Doesn't sound like it's going to the printer, Dave.
It's not coming out of this end.
All right, I'll send it to another printer.
All rise.
matter is before the court for a competency hearing. Do you have a copy of the indictment?
I do, Your Honor.
The defendant stands indicted by the Lake County Grand Jury on May 16th of 2022. Count 1, felonious assault, a felony of the second degree. With an enhanced firearm specification, 4.5 years, and a repeat violent offender specification, and a forfeiture specification for two firearms, magazines, and ammunition. Count 2, having weapons while under disability, felony 3, with the same firearm specification and forfeiture specification. Count 3, having weapons while under disability, with the same firearm specifications and forfeiture specification. Count 4, inducing panic, felony 4, with the same firearm specification and forfeiture specification. The defendant has not been arraigned. The matter came over from the Willoughby Municipal Court, and the defense filed a suggestion of incompetency. The defendant was referred to the court's forensic psychologist for a competency evaluation. Dr. Rinsberg rendered a report dated March 21st, 2022, that it was his opinion to a reasonable degree of psychological certainty that the defendant was, in fact, competent to stand trial. A request for a second opinion was made. The defendant was referred to North Coast Behavioral Health Care. North Coast Behavioral rendered a report on July 13th, 2022. Dr. Bodnar, that to a reasonable degree of medical certainty, Mr. Wynn was competent to stand trial, meaning he understands the nature and objective of court proceedings and can assist in his defense. Prior to coming into court, I was informed by Mr. Shoren, defense counsel, that Mr. Wynn has just discharged him and Mr. Wynn has not yet even been arraigned. Since the question of competence has been raised, I haven't had a hearing on that. And if the defendant is without counsel, so the question is, is the defendant competent enough to fire counsel? Is he competent to be arraigned? Do I have to appoint counsel, continue the case until we can get it on the schedule and new counsel become familiar with the facts of the case, and the defendant doesn't waive time? But I'm not sure he's competent to actually say he doesn't waive time.
It's the state's position, I think, that if competency is still at issue, then the defendant can't be arraigned. And I know under the statute it does permit, should the defendant or future defense counsel, or current defense counsel for that matter, wish to obtain a third opinion, the statute does permit for that as well. So I think at this point that we can't have a competency hearing if the defendant is without counsel.
I agree, and time doesn't run.
Yeah, excuse me. I can keep my counsel because I want to.
Well, you can, but your attorney told me a few minutes ago that you discharged him.
But I just said that I could just keep him because I wanted to hurry up. I want to hurry up and try to get out of here so I could be with my family. Whether if I go to prison or not, I want to hurry up and try to prove my innocence so I can get up.
Well, you don't have to prove your innocence. The state has to prove your guilt.
Yeah, and the state. I know, I understand that, and the state got to prove that. The state got to prove.
You don't have to prove anything.
Yeah, the state got to prove it, and I got evidence and everything to show that I'm not guilty.
Mr. Shoren, you've spoken with your client. He certainly sounds like he understands what's going on here. What do you attribute his terminating you a few minutes ago to?
We had a discussion this morning at the county jail, and at that time he indicated that I was fired, and when we spoke again here shortly before the hearing started, he indicated that that was his position as well. So in a sense, I've been fired twice, both this morning and here this afternoon.
But the only reason why I said that, could you say why I said that you were fired? Because at like 10:41 on the Lake County camera, when he came to visit me, he stuck his middle finger up at me and said, "Fuck you."
Wait a minute, say this again?
At 10:41 in a visiting room, he came to see me.
You mean 10:41 a.m.?
In the morning,
okay.
About 10:41 a.m. because I was in there waiting after he left. So we was arguing with each other, and I was like, he kept telling me, I was like, why you keep telling me all these years? So he hopped up and said, "Fuck you. You can't say I ain't doing my job." He stuck his middle finger at me. It was on camera, but that's why I said that. But I don't want to.
Okay, I mean, you haven't even been arraigned yet. What he's I'm assuming what he was telling you is the felonious assault carries a maximum of 8 to 12 years in prison. The firearm specification, and you can get 2 of them, or does the first one merge into the second? No, the first one merges to the second one on each count, but you can get 2 firearm specifications, and each of those are 4.5 years, as I mentioned earlier. The weapons under disability carries a maximum of 3 years in prison. The inducing panic carries a maximum of 18 months in prison. The repeat violent offender specification carries another 10 years in prison. Is that what you're talking about, what he's telling you?
Yeah, I was, because he kept saying I've got to get all these years, but I was telling him that the felonious assault, I didn't start, the guy started.
Hold on, don't say anything about the case.
Yeah, that's why
your opponent is here.
Yeah, so that's
the
why
prosecutor is here, and what you say can be used against you. What your attorney is telling you is, yeah, if you're found guilty of all of this, you're facing, if you're talking a maximum term, you're facing a lot of time in prison. This is very serious.
Yeah, I know this is very serious, but I'm telling him, I was trying to argue with him and say that I got evidence on this and I got witnesses.
Then don't go into that hearing court.
And that's what I was saying.
Despite him firing you twice, Mr. Shoren, are you still agreeable to representing him, knowing that sometimes tempers get the better of a lot of people, and he just didn't want to hear all those years that you were advising him that he's exposed to here in the case?
Your Honor, I believe our differences are greater than that. Mr. Wynn seemed to want a guarantee of the outcome and questioned whether I had done my job or not. I've been doing this job for over 30 years. I think I know what I'm doing. And if he has questions about that and has doubts about my ability to work on his behalf, I believe it's in his best interest to get the attorney he wants, because he clearly doesn't want my help.
Well, and are you saying that you are either fired and or are withdrawing prior to the hearing on competency, prior to arraignment?
Your Honor, given his position, I don't think I can ethically proceed at this time.
Okay. So, Mr. Wynn, what's presented to me is you're without counsel. And you haven't been arraigned, and I haven't ruled on the competency, and I really can't unless you are represented. And even for you to represent yourself for purposes of those hearings, I'd have to hold an extensive hearing, much more than what time would allow today. The clerk's office closes in a few seconds anyway. So what I'm going to do is I will continue this hearing, give you an opportunity to hire new counsel. Are you indigent?
Yeah.
So you paid Mr. Shoren, or who's paid Mr. Shoren? Family?
Yeah, family paid Mr. Shoren.
All right.
And we kind of spent everything on paying him.
Mr. Shoren, how long would it take you to do a final bill and determine whether you're owed anything or whether you owe them?
I would think we should be able to have that done by the end of the week.
All right. So what I want to have happen is I will continue the matter. I'm continuing the hearing on the competency. There are time limits on pretty much everything that we do, but the state has not caused any of the time limits to be breached. Speedy trial isn't running because this is your motion. It's still pending, and it won't start up until after I hold the hearings. But Mr. Shoren needs to do a final account, settle up with you, either give you a bill for any balance owed or refund to you any balance he owes you. I'm not even going to inquire as to what financial arrangements have been made, because that's none of my business. That's between you and Mr. Shoren. But you'll settle up your financial by the end of this week. Then as one of his last outgoing duties, Actually, he doesn't even have that duty. If you are indigent and you tell me you're indigent, your incoming attorney, and I'll appoint the public defender, will get an affidavit from you swearing that you are indigent, do not have funds to hire counsel, and the public defender's office will represent you. Ms. Alessi, public defender doesn't have a conflict?
I don't believe so.
I don't know anything about the case.
No, I don't believe they do have a conflict. In fact, they originally were on the case before Mr. Shorn was detained.
All right.
So there was a previous finding of indigency and they were appointed.
Oh, okay. So there is, he previously did file for indigency.
Correct.
Okay.
And the public defender was appointed.
But family members paid you, correct?
Correct.
Okay. So the family member's money is not his money.
Right.
And so I'll appoint the public defender to represent him. They'll look over the 2 prior competency evaluations. We'll hold another hearing. We'll get it on the schedule as soon as we can, but it's probably going to be at least a couple of weeks to get that ready. And then if I do find the defendant competent, I will arraign the defendant, and then you'll get on, I'll set a bond, you'll get on with discovery, and then we'll proceed with the case that way. Any other comment on that?
No, Your Honor.
Does that sound appropriate?
Yes, Your Honor.
Mr. Shorn, sound appropriate?
Yes, Your Honor.
Mr. Wynn, you have a...
Yeah, I wanted to say, if you set another bond, do you think you can lower my bond? Just ask.
Well, I don't know anything about the case yet, and I really can't, because the first issue is, are you competent?
Yeah.
And I can't do that until I have somebody that's representing you look at that. You can't represent yourself if you're incompetent, and that's the very first issue that has to be addressed. I can't even hold the hearing on you representing yourself until you're deemed competent. So the competency suggestion actually stalls everything until that issue is first addressed.
Yeah, my people was they was trying to like see if they could bond me out. Like even if they just pay the bond, they was trying to see. But I don't know. They said they don't try to see what they can do. But I was telling them I got a conference hearing with the judge. I didn't know all this was gonna happen today. I thought this was gonna be like that. I didn't know all this was gonna happen. I didn't know I was gonna have to go through this and do all that. My mother got cancer. She about to die or whatever. So I was just saying, like, if they can give me competent, could you please lower the bond if you can?
Well, I have to consider everything that I need to consider. The repeat violent offender specification is alarming because I have to make a determination whether you should even get a bond.
Yeah.
So I have to take that into consideration. The public safety aspect of this. Public safety isn't a consideration in the amount of cash bond, but the question is, should you be entitled, should you get a bond at all with the repeat violent offender specification? So we'll handle it one step at a time, and the first step is get the attorney's thing squared away, then we'll hold the competency hearing, then I will arraign you, and then we'll talk about the issue of bond. And that'll take a couple of hours for a hearing, so it may be a few weeks before I can get it on the schedule.
All right, can I ask you one more thing? I went to North Cross for a long time. Then they sent me to jail. They sent me to prison. And I got out. And then, like, I ain't been in prison more than 2 times. How did I get the repeat violent offender? I ain't been in prison more than 2 times.
Like I said, I don't know anything about this, but just reading the indictment, that's the second specification on the first count. It says the grand jurors further find and specify that you are a repeat violent offender, having been previously convicted of a felony of the first degree, that is an offense of violence, namely aggravated robbery, in violation of Revised Code Section 2911.01A1, and also aggravated burglary, in violation of Revised Code Section 2911.11A2, a felony of the first degree, in the Cuyahoga County Court of Common Pleas, case number CR 08516-704A, on April 27th, 2018, and or aggravated robbery in violation of Revised Code Section 2911.01A1, felony 1, in the Cuyahoga County Court of Common Pleas, case number 08517-314A, on April 27th, 2018. So they're saying you have 2 F1 aggravated robberies and 1 F1 aggravated burglary, and those would qualify you as a repeat violent offender. Now, I don't know if they're true, and I don't know anything about this.
So you the judge, you the judge. So if you would determine that, right? Or like if you read the paperwork, you would know, right? Like if you can help me, like even if I get sentenced or whatever, even if I get sentenced and like try to help me, I'm not a bad person. Even if I get sentenced, you would like know that I'm from the heart. I ain't a bad person.
Well,
like
first off, I don't judge people. I judge their actions. God judges people.
Yeah.
So, like I said, I don't know anything about this case, and I really can't discuss it further because I don't know if I'm talking to someone who is competent because I haven't had the hearing yet.
Yeah.
So, is there anything further today?
No, Your Honor. Thank you.
Nothing, Your Honor.
All right.
Good luck, Antoine.
We're adjourned.